May it please your lordship. Lordship, I'd like to pray for a little accommodation in item number 47. Lordship, we have a little urgency in the matter. Since there are several hearing matters, Lordship, could it be taken up at 2 o'clock or 3 o'clock as
Which
it is
matter?
47, Lordship?
Come on the boat. We'll see to it. Out of turn, though, why should, what is the urgency? Election Commission duty related to Election Commission duty.
We are seeking certain guidelines, Lordship. Since election is in the offing, Lordship.
We'll see to it.
Oh.
Let it come its own time.
May I please your lordship? Lordship, with the consent from the other side, I beg to mention item number 46 for adjournment. As my senior Mr. SK is out of session, Lord.
Who is for the other side? You have consent?
I
You have
am
informed the other side.
my senior is for the respondent number 3.
You have informed the other side.
Yes, lordship.
Adjourn.
Lordship, kindly matter may be taken up on 29th of February.
29th.
Deeply obliged, sir.
My lord, I beg to mention item number 44. This may be 44. This is wrongly listed, my lord.
I'm wrongly listed. Mr. Before the another page of page. So and so, Justice Shyam Sardar.
Lordship, I beg to mention item number 42 with the consent of other side.
Adjourn.
Deeply obliged.
Lordship, I beg to mention item 55 to 58. Read appeal, Lordship. I am led by senior counsel who is out of court due to health grounds, Lordship.
Adjourn.
For it.
Wait, please, lordship. Lord, I think that item number 50, Lord.
Item number?
50. Lord, we are filing our affidavit, Lord. It will take some time, Lord. Can I pray,
How
Lord,
much
this matter?
time? How much time?
Lord, can be taken at 2 today, Lord. During the course of the day, we will be filing, Lord.
15.
50, my Lord.
50.
That undertaking, Lord, your Lord.
That encroachment matter.
Yes.
Okay, 2.
My Lord, I may be permitted to bring on record the affidavit, my Lord.
Yeah.
Deep.
Please place it on record.
Daily list for orders item 1.
No, this matter has already been admitted.
This.
No, matter has already been admitted for hearing. And the
respondent number
service
3 is
report
not,
on the respondent number 3 is not complete. Not complete.
Yeah.
Matter maybe with service report also.
Lordship, it's been more than 30 days and already the notice have been taken. Your Lordship, may be deemed to be served, Your Lordship.
Need to be served.
The division bench just passed to entry mode.
Foreign company.
Yes.
There is a status quo already.
Have you claimed any relief against the respondent number 3?
My lord, in fact, in spite of service of notice, my lord, did not contest the, my lord, before the
In fact, the
report.
office report, the notices remain unserved.
Lordship.
As per the office report,
Lordship.
the notices issued to the respondent number 3 remain unserved. Returned back unserved.
I'll take fresh step in that case. my lord.
Fresh.
So, Lordship, beg to make one submission.
Did the respondent number 3 appear before the learned single judge?
No, my lord, did not contest
Despite service of notice.
despite service of, it was deemed
Who-
accepted. my lord.
With the writ petitioner.
We are
my
a
friend is-
petitioner, your lordship.
Have you sought any relief against the respondent number 3 in the writ?
No, we have sought all the relief in the read petition itself, not separately against the respondent number 3, your lordship.
In the writ petition, you have sought any relief against the respondent number 3 or you sought relief against the NHI only?
NHI only.
Only NHI. Read the prayer clause of your writ petition.
Lordship, I do not have a brief today, your lordship.
Respondent number 1 to 4.
Prayer, read petition. Very nice, no?
यानी तो स्ट्राइको ये तो फॉरेन कंपनी what is the urgency? Why they have?
Relief claim in the writ petition would affect the interest of the respondent number 5. my lord. Otherwise, my lord, there is no direct prayer, but then if the relief is granted, in that case, respondent number 5 would be affected.
Respondent number 5, they are praying simply what they have prayed. The respondent number 1 to 4 may kindly be directed to make the payment of rupees 11 crore or rupees to this petitioner.
Lordship, which
After
was payable to
deducting-
respondent
After
number 5.
deducting the same from the payable amount to the respondent number 5.
5.
Naturally, once there is you have not disputed that he has not completed the work. It is the subcontract was approved by the NHAI. And as per the terms of the contract, you are supposed to, if the main contractor is not making payment, you are supposed to make the payment. That is
No,
all
my lord,
admitted here.
so far as completion of the work, my lord, that we have not, my lord, agreed
However,
upon.
it
my
may
lord.
say completion of the work so far as the work assigned to this subcontractor.
Lordship, my lord.
He has already completed and you have not disputed that.
No, my lord, that, my lord, he nowhere in the writ petition, he said that the work assigned to him has been completed, nor my lord, our admission to the fact that he has completed the work. What we said on the termination payment, we have,
Para number 34 of the learned single judge.
Lordship, my lord. That's what, my lord, one of the ground, my lord, I have taken on that, my lord.
Contract agreement in question, but
Lordship.
subcontracts, the subcontractor, the petition was given after approval from the concerned
Lordship,
respondents. various reports which are part of the record would demonstrate
Yes.
that the work which was entrusted to the petitioner was completed in all respect. In fact, this fact also admitted by the learned counsel for the respondents.
And that is we are,
There are various clauses in the contract from which the petitioners appear to assign assigns of the principal contractor numerous communication, including to fortify the extent of the petitioner. Respondent number 3 and 4 in affidavit opposition. That's, the
Honorable.
timing,
Honorable single judge has misconstrued the statement that was made in the, my lord, affidavit in opposition by the, my lord, NHIDCL, my lord. It is taken as if we have admitted. We did not admit so far as completion or payable to him. What
whatever it,
we said,
whatever it may be, ultimately he has played relief, he sought relief against only the respondent number 1 to 4,
Lordship, my lord,
the
that-
appellants.
yes.
And not before the respondent number 5, we can do one thing, we can waive the service of the respondent number 5 for the time being, respondent number 3 for the time being. And hear the matter.
Lordship, that can be done even in, my lord, before this, my lord, single judge also, respondent number 5 did not contest.
Did not click it.
So we have made him a, my lord, a
As
performer
per the office
respondent in
report,
fact.
The notice upon the respondent number 3. Receive, answer, full stop. Taking into consideration the fact that in the writ petition, the respondents have claimed relief against the appellants only. And though the appellant, though the contractor, main contractor, a principal contractor was included as respondent number 5 in the writ petition, but despite service of notice upon it, none has appeared. Full stop. In such circumstances, we deem it appropriate to waive the service of notice upon the respondent number 3 for the time being. Raise this matter for hearing. When
And it is convenient to the court, my lord,
Next week, your lordship, any date here?
twelfth of March.
Returned answer, right? Returned.
interim order passed earlier, may kindly continue.
Interim order if I need to continue till next week.
Right.
Item number 2.
Very pleased, your lordship. My lord, today, your lordship, my lord, as per earlier order, today is to consider my interim prayer, my lord. Lordship. As since my lord continuing art cutting is going on, my lord.
Who is the respondent number 15?
Respondent 13 is the, my lord,
13 or 15?
13, my lord. He is the,
Respondent number 13.
yes, he is the contractor within the, my lord, engineer, PWD engineer.
Who is
Yes,
carrying out the work,
yes.
service of notice upon.
But
Yes,
that
lord.
person is.
It is not been completed, lordship.
that will
As
come
per
in, my lord.
office note, lordship, service upon respondent number 13 is not complete.
My lord,
Is not complete.
my lord, I have a submission, my lord. I have filed one additional affidavit, my lord, because of the urgent situation. Most of the people, my lord, during after the PIL also, they have been, my lord, their land has been continuously cut. This respondent 13 is under the authority of respondent number 8, my lord, executive engineer PW. We have the representative council is there, my lord, and we have also served copy. And the chief engineer is respondent 7, my lord. Now, my lord,
Ultimately, that if we are going to pass any order
yes,
as an interim measure,
yes.
certainly the contractor is the first person who is going to be affected. So get the notice out upon.
My lord, thing is that, my lord, my friend, my lord, colleague friend, my lord, the, for the engineer, my lord, PW, my lord, they can serve and submit a report, my lord. And one more prayer, my lord. My lord, the continuous grievance of this is that their lands, we are not against the road, my lord. Two lane project is,
You are saying that
but this village land, my lord,
they are carrying, they are carrying the construction activities.
there is
beyond the-
no,
Beyond the, this alignment. This is what your prayer is.
our is that the road project is passing through the villages of these affected villagers. but no right to fair compensation act. I have brought the settlement plan, my lord, in my additional affidavit. I got from the net, my lord. They have suppressed this, the act is prevailing there, and no, nothing has been followed, my lord.
We'll consider that, but for that purpose, for passing any interim order, at least the contractor is required to be here.
Yeah.
Be here.
If the authority,
As
they
per the
file,
office report. The service of notice upon the respondent number 3 is not complete.
30.
13 is not complete. Let fresh notice be issued to the respondent number 13. Returnable on 6th of March 2024. Requisites were filed in 2 sets. One set be given justice to the learned concept for the petitioner for service upon the respondent through PWRD EAP department, and one set be sent through registered post.
My lord,
Within a period of 2 days.
my lord, my interim pair may be considered on the next day.
We'll consider it, it is on the record, we'll consider.
My lord, one more prayer, my lord, I have filed one additional affidavit. Your lordship may direct the authority to place on record. Registry may be directed, my lord.
The additional affidavit filed on behalf of the petitioner be placed on record.
Obliged.
Item number 3.
What happened, that meeting took place or, item number 3, na? It is-
Yes, Lordship, in terms of the earlier order, Lordship, we have taken registered step
Item number 4.
in respect of respondent number 6, and also we have filed a justice service. And to that effect, we have also taken filed an affidavit. So Lordship, the service in respect of respondent number 6. Okay. Is deemed to be served. Lordship.
Where is the affidavit of justice service? In record. Yeah. Justice service.
DK. That's the affidavit filed on behalf of the appellants. Contending that the notice upon the respondent number 3. Six is duly served. Full stop. In view of the above, the notice. The service of notice upon the respondent number 3. Yes, 6 we treated as complete. This admission, this matter for admit ho gaya
No, yet to wait.
for admission. Which date?
Second week of March.
Second week of March की कोई date है?
Lordship, may kindly fix a date if that is possible. A date may be fixed, Lordship. Date.
Yeah.
14, highly on that.
Lordship, the interim order may be continued.
Interim order if any to continue till next day.
Problem.
Item number 4 for admission.
The academic committee has taken a decision, my lord.
Where is that?
The decision I'll bring on an affidavit by today, my lord. I just got the information. The equivalency has been rejected. Equivalency has been rejected.
Rejected.
Equivalency played for has been rejected. I'll bring that on record. my lord.
Learned counsel for the secondary education department has submitted that the expert committee in its meeting dated 21st of January,
Number 2nd of February, 2024.
second of February 2024 has already resolved, has already taken a decision regarding the equivalence of degree possessed by the appellant. He placed some time to place on record the minutes of the meeting. Based on
A week, my lord. A week hereafter, I'll place it by Monday, my lord.
next meeting. Based on 21st of.
My lord. Obliged, my lord.
It is a petition. Petition.
Item number 5.
May it please your lordship. My lord, by last order, this honorable court was pleased to call for the record of the WPC, my lord, where there is a report, my lord, regarding the present status of the, my lord, flat, where
From
the,
the SHO concern. From the SHO concern.
no, from officer in charge, police station. Concerned police station.
It is the ordinary election.
There is no such order of the court.
Lordship?
There is no such order.
WPC का record.
Yes, my lord.
Iska record, the court has called for which record?
My lord, the earlier WPC, my lord, writ petition and there is a report also, present status of the flat in question, my lord, where the present appellate was used to reside, my lord, in rent, my lord. Allotted to the housing board, my lord. And there, in this report, my lord, the police has submitted, my lord, that the son of the petition along with one other person was present that period of time.
There,
Yes, my lord.
but that,
To myself,
that was before the single judge also.
yes, my lord.
But ultimately, why you have conceived this, that your allotment was cancelled way back in the year 2017?
My lord,
You have not mentioned that.
my lord, I have no knowledge, my lord. After filing of the
We
writ
have no
petition, my lord,
See,
lord,
you have no knowledge, then it can very well be assumed that you are not residing in that house.
my lord, they have not shown also any, my lord, record pertaining the notice was served to me, my lord.
Was there.
Yes, lord.
You have simply said, "Yeah, I was out of station and therefore I was not aware of that notice and therefore no
Lordship.
reply was filed." This is what your case is.
My lord, subsequently, they have issued a notice in the name of the, my lord, one Ritipun Deka, my lord. So my prayer is, my lord,
The
what,
learned single judge has benefited you only on the ground that you have concealed this fact.
along with
And
another ground,
apart from that,
that, yes, my lord.
the Aadhaar card address and the address of the flat is altogether different.
My
That
lord.
is also there. That's so many.
My lord, by filing affidavit, I stated all this, my lord, because at that point of time, my lord, it is not possible for me to, my lord, address in the name of.
Every
flat.
time that you have said,
My lord.
I have given the address of my
Yes, my lord.
sister, since I was not able to get the address in the Aadhaar card connected, So only nothing.
But
else,
my lord,
no
fact is that, my
material,
lord-
No proof, no date,
Lords.
nothing.
My lord, fact is that, my lord, the police found my son, my lord. I was also there, my lord, that police has not reported. My lord, my humble prayer, my lord, one opportunity. My lord, my lord, I am ready to pay the area rent also, my lord. And she is the,
We are not
ready.
concerned with that. We are ready for them.
she is the, my lord, only lady, my lord, died. Husband also died, my lord. And
There in the pleadings altogether different stance you have taken. You have said my cousin brother and my another
Yes,
driver was
Lord.
living there. Seems
my lord, she was ill that time, my lord. She used to reside in her sister house, my lord.
why?
But her family is there, my lord.
That's what, these allotments of flats made by our housing board,
Yes, ma'am.
is it treated as rent under the ULC, Urban Areas Rent Control Act?
No, my lord. No.
Yes,
My lord. So my humble prayer is, my lord, in the provision of section, my lord, 54 of the Assam State Housing Board Act 1972, my lord.
yes.
There is also a provision, my lord, even after eviction of the order, my lord, if, my lord, the authority deems it fit, my lord, subject to, my lord, the area rent and others, my lord, they can consider, my lord,
First of all, though,
lordship.
it is an admitted position that your allotment was cancelled way back in the year 2017.
2007.
Yes,
So, as per the appellant, she is not aware about the same. But
lordship.
since after filing of the reply,
Right.
you are aware of that fact, then there is a provision. This to file an appeal before the government. Have you filed any such appeal?
My lord, I have filed a memorandum, my lord.
What do
You will
you
find,
what do you mean by memorandum? Appeal?
Lord-
Section 51.
yes,
or
my lord,
52. What is this? 57.
lordship.
Any
That-
person
that
acting
was-
by any order of competent authority under section 54 and 55 may within 1 month from
Lordship.
the date of service may appeal to the state government.
No, my lord, that.
Why you have
alternative,
not filed appeal? There are so many hurdles.
Lord.
You have to file an appeal. appeal apne, we have not preferred any appeal against the eviction order despite knowing this, though in year 2022 or 24, whatever it may be, because the government has the power to condone the delay also.
My lord, they have filed the affidavit in opposition only in the last part of the 2023, my lord. Yes, my lord.
Avail your remedy. Otherwise, in this writ petition, looking to these disputed questions of fact, certainly the learned single judge has rightly not interfered. Apart from that, separation of material fact.
Yes.
Sorry.
So, my lord, I humbly, my lord, let me, lordship, I will appear before the, my lord, appellate authority. Lordship, may kindly observe that much, my lord.
Observably, will record your statement and grant you the liberty.
Lord, that will.
The learned single judge has dismissed the writ petitions filed by the appellant. Observing that the cancellation of the allotment of the flat was cancelled. The allotment of the flat to the appellant was cancelled way back in the year 2017, that is on 18/9, what's the date of cancellation?
18/9/2017.
18/9/2017 by the competent authority. However, the appellant has not disclosed, has suppressed this fact, and therefore suppressed this fact, and therefore she is not entitled to get any leave in the extraordinary jurisdiction of this court. Full stop. At this stage, the net, once for the appellant has submitted that he may be allowed to, has submitted on instruction that the appellant be allowed to withdraw this writ appeal with liberty to her to file an appeal before the state government under section 57, under section 57 of the Assam State Housing Board Act 1972. Dismissed with liberty as prayed for.
My lord, till then, my lord, filing of the, because there is a status quo order by this honorable court also.
Sorry, we are not.
Lord.
Of course, the
Lord.
state government has power to stay that eviction order.
Masam,
Item number 6.
Separate state petition is there.
my lord.
So the vote is
My lord,
Item number 6.
May please,
Yes,
Your
ma'am.
Lordship, in this item, on earlier occasion, honorable court directed to take instruction on behalf of respondent number 2, my lord. So that matter may be taken on Monday, my lord, so that I may be place that instruction.
Mr. You have submitted your objections in the public hearing.
Yes, my lord.
So what happened in that?
My lord, nothing has, my lord, given any reply
So
to that.
any permission was granted for establishing this cement factory or what?
My lord, as per my learned friend instruction, my lord, already, my lord, no objection has been given, man.
Objection you have given.
Yes.
What happened to those objections, whether they have been decided till date or not?
No, my lord, that part is not.
Oh, how
Well-
you can interfere at this space, sir? Once you have filed the objections
Yes, ma'am.
and those objections are to be taken into consideration by the competent authority, why should we interfere in this?
My lord,
PIL?
my lord, lordship, I stated in paragraph 8, my lord, though there is a meeting was conducted, my lord, giving public notice, my lord. But I asked for the minutes of the meeting, my lord, that was also not provided, my lord.
Whether they have taken any decision or not.
My
Till
lord,
date, final
yes,
decision.
yes, definitely, my lord, after taking decision, they have, the pollution control board already given no objection, my lord. And the,
The PCB has given the NOC.
yes, my lord, as per my learned instruction, my lord.
In fact, in such matters, environment clearance is also required. So that environment clearance has also been duly given by the State Environment Impact Assessment Authority under the Ministry of Environment Forest.
So EIA proceedings have been
Yes,
concluded.
all done. And after, prior to that, the public hearing has been done by due
That's right.
public notification. All the objections has been
So
heard.
where is the decision of the EIA?
Yes, I have a copy, in fact, even though the learned central government was asked to clarify on this aspect, but still I have one set.
My lord, it seemed to January 5. it is given.
That's EIA, Environment Assessment. उसके brought it on record. बिल्कुल हमें चाहिए था ये.
Then the minutes of the meeting were
Yeah.
already uploaded on the portal
That's my lord. But
in
if-
October 2023. You can obtain from the whatever the decision or they have
My
taken in
lord,
the meeting.
we
you can
approached
obtain it.
there, my lord, asked also, my lord, that has not been published also, my lord.
Published here, they have specifically said public hearing was conducted and
that
completed by
was-
the pollution control
That was
board
there, I have annexed,
on 25th of August. The
Yes, ma'am.
proceedings in the public hearing were submitted, uploaded at SEIAA and the minutes were uploaded in the Parivesh portal on 14/10/2023.
Yes, long time back.
my lord.
That is there.
That notice
the
I
public
received from the
domain.
online, my lord.
Hmm?
Notice I have found in their portal, my lord.
Yes,
Yeah.
you have simply attached a notice that this public hearing notice was there and we apprehend that they will not objectively consider objections. This is what your
Well-
submission in the petition is.
Yes, my lord, we, in fact, we are aware of the meeting also, my lord, but, my lord, gathering some people only, my lord. They have conducted the meeting, my lord. And this situation, public, these are the, my lord, public who are suffering, my lord. So they, my lord,
Once they have given the public hearing
lordship,
and considered your objections, whatever the objections were there.
Lord.
Now either you challenge those minutes of the meeting in the writ petition, you have not mentioned anything.
Not-
You have simply said, "Okay, we have submitted our objections and that's all." When you filed this petition,
oh, my lord. It's, my lord. It's first listed on
in the year 2000, in January 2024 only.
Yeah.
Whereas the decision was taken on 14/10/2023, you have not challenged that decision.
My lord, we have not found anything, my lord, my lord, we,
It is
that's why, my
there.
lord, now,
So
so my lord,
their statement is, this
Lord, sir.
statement is wrong.
no, my lord,
Have
that
you
I
checked
cannot
it?
say. So, my lord, my humble prayer is, my lord, since they have submitted this, my lord, Lordship may given liberty to challenge this unless, my lord, otherwise, my lord,
This writ petition. The design of public interest petition. Despite by petitioners. Seeking it there. That. The respondents. I don't know. We directed to. that a declaration be issued that the action of the respondents of contemplating to establish 300 TPD in bracket TA. Get it quoted in this. Establishment. May kindly be set aside and necessary orders in this regard be issued. Full stop. In the writ petition, the petitioners have pleaded that the Pollution Control Board has invited objections in the public hearing from the public at large, environmental activists, groups, NGOs, etc. And they apprehend that the Pollution Control Board may not consider the objections filed by the residents objectively. Stop. The net counsel appearing for Pollution Control Board has submitted that public hearing was conducted and completed by the Pollution Control Board, Assam, on 25th of August 2023. And the environment clearance was granted for establishment of the cement manufacturing, the concerned cement manufacturing unit. It is also stated that the proceedings of the public hearing were uploaded on SEIA capital letter, and the minutes were uploaded in the Parivesh, it's also Parivesh be also in the capital portal on 14/10/2023. At this stage, the net counsel for the petitioners on instructions has submitted that he wants to withdraw this writ petition with liberty for the petitioner to challenge the to challenge the decision of the Pollution Control Board of granting environment clearance for establishment of the cement manufacturing unit in question. Dismissed with liberty as prayed for.
Lordship, in fact, may I clarify that environment clearance has been granted by the State Environment Impact Assessment Authority, which is under the Minister of Environment Forest, not the pollution.
Will note it.
A copy of that may be supplemented. A copy of that minute may be.
That is under public domain, in fact.
This for.
Mr. Uddin, you are not understanding. This is uploaded in October
Right.
2023.
Right.
You don't follow this simple thing. You download it from the website.
Obliged.
Item 7.
May I, my lord? My lord, before my senior colleague, my lord, start, my lord, with an apology, I am paying a little accommodation today, my lord, because the file has been misplaced in the office, my lord. Any day, next week, any date, my lord. When I'm
So if it is misplaced, then what will happen in the next week?
no, my lord, I have to search.
You have to search.
Although I searched in the morning, my lord, I could not find it.
Yes, Mr.
Next week,
My lord, after 27, my lord. I have-
At the request of the consent of the each time, the appellant, list this appeal on to, so.
Obliged. Obliged.
Petitioner or-
Supplementary list for orders. Item 49.
Make it is a loss.
Yes,
Well, in this case, well, the IA is for combination of delay of 129 days. There is a delay,
what is on merits?
my lord. Well, in the impugned judgment, my lord, the learned single judge has directed the authority to make an inquiry regarding the population pattern, whether,
What's wrong in that?
my lord.
What's wrong in that?
So what happened, my lord? As population pattern of general category is more than 40% and SC category is also more than 40%, the judgment is yet to be implemented. The private respondent, my lord,
What material you have placed on record? That the SC category is also more than 50%. Where is that? From there we,
it is not on record, but my
Where
lord,
the-
as per the
where is
instruction,
that record? Which is that record?
it is not on record, my lord.
Not on record, then simply on, by making a oral submission, how can we believe?
But my lord, there is more than 40% of general category, but the appellant is yet to be appointed. Despite
That
the
is the
judgment,
direction. Is the only direction.
yes.
If the population is more than 40%, then appoint the appellant.
My lord, but the authority, what they have done, they are sitting over the judgment, my lord, and they are allowing the private
Contempt,
respondent.
sir. They are sitting over the judgment and not complying with the order, file a contempt.
But due to her marriage, maybe to
Initially,
Avail appropriate remedy if they are not complying with the direction given by the learned single judge, avail appropriate remedy available to you.
First may observe that and close the appeal.
Okay. The matter comes upon for consideration of the IN number so and so. With a prayer to condone the delay of 129 days in filing the present appeal. Stop. And it. Something for the appellant. Has submitted that the appellant has sufficient cause. But the appellant has satisfactorily explained the delay in filing the present appeal. However, it is also submitted, full stop. It is also submitted by the counsel for the appellant that the respondents are not complying with the direction given by this court, given by the learned single judge in the impugned judgment. Stop. We are of the view that if the respondents are not complying with the directions given by the learned single judge in the impugned judgment, the appellant has a remedy to initiate appropriate proceedings against the respondents for non-compliance of the directions given by the learned single judge. Stop. Apart from that, having gone through the contents of the application, the IA number so and so, we don't find any sufficient reason to condone the delay of 129 days in filing the present appeal. Consequently, the IA number so and so is dismissed. Appeal dismissed.
liberty may be granted. my lord. Liberty may be granted to appropriate.
Liberty we have already observed. There is no question of liberty.
Obliged, my lord.
Item 51 for admission.
Well, we have preferred this writ appeal against the judgment and order dated 25/1/24. Well, the another writ appeal, item number
53.
59, item number 59 is connected, that has come for
59.
hearing.
59 is connected.
Yes, my lord. But this appeal may kindly be taken up along with that, my lord. That has come for hearing today, my lord.
You are appealing for the respondent.
Yes, madam. I'm appearing for the writ petitioner.
Well, here
Taken up together, my lord.
নকৰো বুলি কোৱা নাই।
Yeah. Company के नाम पर देते हैं। कंपनी के नाम पे जो काम है वो दैट इज द लॉजिक। ठीक है लगता है निपट सकते हैं आगे, लेकिन वी कैन टेक इट अलोंग विद we'll take it along with that.
No, but, oh,
Take it along with 59.
59.
59 did a call paper. Yes.
Item 52.
May I please, your lordship? Lordship, before I take your lordship to the impugned order, lordship may kindly come to annexure 2, my lord, page 54. This is the order passed by this honorable court, my lord. This is the third round of litigation before this.
Page
honor-
52,
54, annexure 2, my lord.
54. Yes.
My lord. Page 61, my lord, paragraph 2 onwards, I am reading. Lead petition has been filed by the BSNL challenging the order dated 8/4/14 passed by the learned Central Administrative Tribunal so and so in OA number 205/2009. The private respondents before this court were working as part-time or casual workers in BSNL. The admitted position is that the part-time casual employee has to work for at least 240 days without a break in a calendar year for being entitled to temporary status regularization as casual workers. Since the private respondents before this court were not being a temporary status or regularized as casual workers, they filed a OA number 205/2009 before the CAT. The predate case of the petitioner before the tribunal was that they had worked under BSNL for 240 days continuously in a calendar year and were entitled for regularization. Moreover, the grievance of the petitioners was that many part-time casual workers who were junior to the petitioners were retained by the BSNL, but the petitioners were placed under.
Mr. Bakshi, why don't you place the impugned judgment
Yes, my lord, because they are to understand the factual matrix, my lord, it is necessary because there have been earlier two rounds of litigations before this honorable court. Two directions were made to.
What is your case for the present? Please place it.
Yes, same way, my lord, pertaining to same way. Original application 2005, 2009, my lord. Lordship may come to page 62, next page, my lord. The order of the tribunal was challenged by the BSNL before this court in a number of writ petitions. The lead case being so and so. The writ petitions were disposed of by the division bench of this court by the order dated 13, observing that since the subject matter of the writ petitions were conferment of temporary status to the writ petitioners,
चार हफ्ते में implement करने के लिए they have not more than
Lordship,
Direction was to implement the order in 4 weeks.
Lordship may kindly come to 5 page.
Please answer the question. Mr.
Yes,
The direction was to implement the order within 4 weeks.
yes, my lord.
This order was passed in August.
Yes,
4th
my
of
lord.
August.
Because
You
on
come
wrong
on
specs, yes, ma'am.
You come on 17th of Feb.
Yes, ma'am.
So that is almost 5 months after the judgment.
Yes, my lord. I
You
have
not
given the
complied.
explanation, my lord. Lordship may kindly come to paragraph 5. Specifically, there was a direction to 642, file number 642. It was the case of the applicants that in the file number 62, note sheet number 1 to 6, they can prove their case. But the learned tribunal below has kindly come to the referred a different file, my lord. Lordship may impugn order annex 3, my lord. But annex 3, Lordship may kindly see.
Page number?
Page number 67. Paragraph 10, my lord, page 81. This OA was taken up in pursuant to the order of this honorable court, my lord, wherein reference was made with regard to 642 file, note sheet number 1 to 6. But without, they have in the submission, in the argument, they have changed their line, my lord. And it has been, my lord, paragraph 10, my lord, the applicants in their rejoinder to the additional written statement had enclosed a copy of the note sheets. But the respondents never claimed that those documents are fabricated or false. However, simply denied and stated file number 672 is not available. But the question is, Rashid Malik kindly see in the order of passed by this honorable High Court, my lord. Paragraph 65, page 65, my lord. 65.
Yes.
The writ petitioners has challenged the aforesaid order by the tribunal inter alia on the ground the tribunal had not considered valid evidence while passing the order. Moreover, the council was not even heard before passing the order. It is also urged by so and so for the writ petitioner that the tribunal ought to have relied upon the statements of the learned counsels for the petitioners and have referred to file number 642. This is very well, wherein it is allegedly recorded that the private respondent had completed, allegedly submitted, completed 249 continuous working days without seeking explanation from the BSNL.
If the tribunal has put mentioned some wrong number of the file,
Yes, my lord.
file the review.
My lord, not only file, note sheets, they have in the rejoinder, Roshi may kindly see, paragraph 10, my lord, of the impugn order, page 81, my lord. In the additional affidavit, my lord.
Just a minute.
Lordship, for a moment, can. There is no 642 file, my lord. 672. My lord, section 22 has not been complied with.
Now, what the single judge has decided? As a CAT ka order, okay, fine.
Yes, my lord, that I have annexed in the very CAT order, my lord. The impugn order, my lord, annex 3, my lord. The operating part, my lord. In the rejoinder, only they have filed a rejoinder with no notice, my lord, only 2 certificates of the SDA, my lord. With no evidence, violation of 22.
Notice. Returnable on. Well,
My lord, let it be 1 month.
how many people are there?
My lord, 39, including,
Will you able to serve them
my lord,
within 1 month?
let it be 2 months then.
6 weeks. So notices are returnable.
My lord,
6 weeks, dasti.
when operation of the impugn order may be,
It's a order of August or कब का है order?
yes, my lord, I have given my explanation. Why could not I come?
Why?
My lord,
What is the
paragraph 22, my lord,
Yes, 3.
because
There are 22.
yes, my lord.
Yes, read.
Page, my lord, 28.
Yes.
My lord, paragraph 23, my lord, that there has been some delay in preferring REIT as BSNL has never considered engagement of casual labor as a matter of policy. Therefore, any engagement of this litigants admittedly working under the contractors, my lord, is beyond the policy of the company, which is a public sector undertaking under the department, telecommunication, GOI, and there is a complete ban on engagement of casual labor, DO2 since 3385 for all.
How you are explaining the delay?
Because, my lord, it is, if your lordship goes to the order, my lord, this is not, my lord, there are ambiguities in the order.
Let them serve, then only will.
My lord, they have come up with contempt petition.
The
My lord,
period for interim relief shall be considered after the service of notices upon the respondents.
yes, my, because they have come up with contempt, my lord.
That's why only you have
Yes,
rushed to this.
yes, I'll deeply oblige, deeply oblige.
That is the only, otherwise there is no question of coming.
Yes, my lord, deeply oblige.
Yes.
Item 53.
Go outside timeline we are making up.
Yes.
Okay.
Page number 239 on that day.
That's it. Be there. Lordship will find 238.
Yes.
238. Let's see, the regulation will be called National Council of Teachers Education Procedure. I have to give a written submission.
Yes, 238.
238. Regulation, Lordship, 1, Roman 1. Lordship got it.
regulation will be called National Council of Teachers Education procedure to be followed by the Regional Committee Regulation 1995. This shall come into force on the date of their publication in the official gazette. Now, Lordship will find it was notified on 24th February 1996. Lordship got it. Now, I will take your Lordship to the page 240. 240.
Yes,
Lordship will find 7, regulation 7. Lordship got it.
time limit for making
Yes.
application.
Every institution offering a course or training in teachers education immediately before the 17 August 1995 shall make an application so as to reach the concerned regional committee within the period of 6 months, that is 16 February 1996. Lordship got it? The 16 February is the last date, and it was notified on 24th February 1996. So after the last date, it was notified in the Gazette. That is why, Lordship, no college under the regional committee all over India has not applied for recognition within the 6 months. There is no possibility of filing application. Along with the list of dates, I have enclosed one copy of the Lordship recognized college of Regional Committee of Northeastern Region, which is under the Regional Committee of Bhubaneswar.
So submitted in compilation.
Compilation also.
Where is that?
Lordship will find at page 14 of the compilation list of dates. Lordship. Okay. List of dates. Lordship.
Yeah. Page 14.
Page 14. Lordship.
14. 14 is there.
Lordship will find the colleges which are recognized by the Regional Committee Bhubaneswar.
The list of recognized teachers education institute.
Yes, Bhubaneswar.
Yes.
Regional Committee Bhubaneswar. Not a single college has been recognized in 1996. No one has applied for recognition in 96. All over Assam and Northeast, under the Bhubaneswar Regional Committee.
Oh, what you are referring to? What you are referring to?
I'm saying, Lordship, the last date of filing application was 16 February 1996
Yes.
and notified on 24 February 1996 regulation. So within 6 months, as
Have
per,
to apply.
no one had applied. No, not a single college.
From this document, how can we get this?
This Lordship will find column. Lordship will find date of order for regulation. Last but 3.
Yes, date of order of the
Order and the session.
you mean to say that before 1996, this none was recognized.
None was recognized. We are the academic session of 96-97. We are academic session of 96-97. Before that, Lordship will take another thing. Page 240 again.
Yes.
7B, Lordship. Page 240. Lordship.
Yes.
May I read, Lordship? 7B.
Condition of recognition.
Every institution intending to offer a course or training in teachers' education shall make an application so as to reach the concerned regional committee by 31st December every year for commencement of the course having from the next academic session. So in this particular case, also last December was the last date for filing application 1996. we are taking admission in session 96-97 before the last date.
6, 7. Yes,
Before making last date of filing application, we have taken admission in the college. We have passed out from Assam University. Secondly, Lordship will find in the present college, as per 16 of the National Council of Research Education Act, Section 16 of National Council of Research Education Act, the Central University, Assam University, Central University, no university can affiliate any college or conduct any examination without recognition of NCT. Lordship, this Assam University, which is affiliated college, under which we are the affiliated college, which from we have passed out, was not made party in this case. Neither our affiliation was challenged before this honorable court, that without violating the provision of the NCT Act, that has been allowed, affiliated, the college has been affiliated. In fact, Lordship will find the public notice, page 188.
yes,
Page 188 of the appeal.
yes.
That is a public notice issued by the National Council of Teachers Education, informing that in the last public notice, there are third Lordship, 188.
88. Yes,
Under section 14 of the National Council of Teachers Education Act 1993, every institution offering intending to offer a course of training teachers education on after alternate day, that is August 17, 1995, has to make an application to the concerned regional committee of NCT for recognition in the prescribed format and manner. The term of institution has been defined, it is not necessary. In the last public notice that appeared in various newspapers in April 1987, all such institutions were advised to submit their application latest by May 15, 1987 to the concerned regional committee of the NCT. A number of institutions which could not apply for recognition for various reasons in time have requested extension of time limit for submission of their application for recognition to the concerned regional committee. Matter has been considered and keeping of the difficulties experienced by several institutions, it has been decided to extend the last date of submission of application to August 18, 1983.
yes, perfect. It's the date of application. Apply for 12 days. It is these are the three occurrences. The ratio of the reason that the regulations are. Adopt the regulation. Or we have passed it. Single year में भी उसी basis पर पानी अलग नहीं पड़ेगा. You supply us the copy of that division bench judgment?
Lordship.
And
That
the
is
single
Lordship will
bench
find.
judgment.
Lordship will find that is in the records.
Thought,
Lordship, the appeal member. Lordship will find page 180.
1 second, Mr.
180.
Institute itself had not made it taken under the ordinance. The ordinance had commanded for the 15 people there. It window gate. What do you file it? This case people have not filed. So what is the so it's the value of that is not in. But it's yeah. Oh, it is not, the timeline is not in consonance with this page. The 29 December, 29 December. They were done. For regulation part. Regulation part. Considering this, that is included the property of there is an application. That it is. So I have yes. They were to do 29.
In fact, look,
In there.
188.
Lordship. Division bench judgment start from 180,
Is the order, division bench order,
181, from page 181.
181.
Same college, same year, same academic session.
Similarly situated person.
Same college, same institution, same year. Against that order, looks SLP file. SLP difference. So, Lordship, in this particular case, the Supreme Court has dismissed the SLP file against this same order, same college, and point of argument was the same. And that was affirmed by the Supreme Court. Secondly, Lordship, the argument advanced by my learned senior was also consideration before the Allahabad High Court in the same matter and same thing. And Allahabad High Court single bench said what my senior has submitted, that this court cannot extend or interpret this section. Otherwise, then it was as per provided in the act itself. Against that order, Lordship, division bench appeal has been filed before the writ appellate court. And Lordship will find the original order at pace, the compilation, Lordship will find the judgment, compilation of judgment, Lordship.
This one, compilation of relevant act decision, this was supplied by, I think so. This was not by you.
Lordship, Sampurna Samachir University, Lordship.
Compilation.
I have given earlier, Lordship. Page 1, Lordship.
Yes,
Lordship, single bench judgment is page 1, Lordship,
one, yeah.
page 1. And I will take your Lordship directly to the page 13,
Page,
13, Lordship.
yes. Yes,
Lordship. एक minute. Lordship, page 13, para 21.
yes,
This court, Lordship got it.
yes.
This court cannot issue a writ of mandamus directing the respondent to act contrary to the provision of the act. The violation of the law, its stance must be objected to all concerned. Court under Article 26 Constitution of India shall not encourage violation of state law on account of equities, or in any case, these equities have not been properly pleaded and applied. Apex Court repeatedly held that the court shall not, on account of such pleading, dilute the provision of the act. That was a submission by my learned senior. That has been recorded by the Honorable Single Judge. Thereafter, Lordship will find the said judgment was challenged, page 16. Page 16, before the division bench writ appeal. Lordship will find page 18. This is Sampurna Sanskrit University, Varanasi. Page 18. Page 18 is the case which was under challenge, along with others.
Yes,
Now I'll take a look at page 20.
yes,
Last paragraph. It will be sent therefore that application for recognition have to be made to the regional committee mentioned therein on the basis of appointed day. The period of 6 months would run out and application would have to be made to the month of February 1996. However, the council had not nominated its members a regional committee by that date. And the regional committee came to be formed 2 months later than the last date of April 1996. It is strict period of 6 months of outer limit for making an application for recognition where to be given effect now. None of the continuing institution would be eligible to grant B.Ed degree, and that would be an absurd state of affairs. What happened? What was the last date of making application for recognition was extended by an executive notification made by the council. At first, such date was extended up to August 1997. Again, there was another extension as last date was 1999. By second extension, it was 31/3/1999. Now I'll take a let's shift to the fifth paragraph. The basic finding, Lordship got it.
yes,
Basic finding of Lordship which has gone against the appellant are as follows. Degree, however, 96-97. I affiliated college or university for the years 97-98, 98-99 for both faculty of education of university affiliated college is not valid. As the university and the college were not recognized for this academic session, these qualifications shall not be treated to be valid for the purpose of perusing the special BTC course in public employment. Some submission were attempt to be made before us that extension of last date by the National Council first up to August 1997, again March 1999 is invalid. This submission has got to be rejected, as otherwise all recognition of B.Ed course at all colleges would fall to the ground. Last portion, Lordship will find. Page 22. Appeal is allowed. The order appeal is set aside. It is declared the degree for academic session 96, 97, 97, 98, 98, 99. And indeed, all academic years produced earlier to the Faculty of Education University of any academic session is valid. And thereafter, Lordship,
97 or expected 99.
and thereafter, Lordship, the second judgment also, the same Allahabad High Court affirmed the same things. That is, Lordship will stand at page 24. I have obtained a certified copy. Same thing has been held, and division bench affirmed the same principles.
So the matter was carried up to Supreme Court or not?
Lordship, that I cannot, Lordship, I cannot collect, Lordship. Secondly, Lordship, I have also collected one judgment from the website that is of the Rajasthan High Court. Rajasthan High Court, where, Lordship, the provision of section 16(3) was under challenge. that affiliated college, without affiliation of the NCT, they cannot apply for different college and other things, where their provision has been struck down. It was a para 34, more, yes, para 34. Para 34 also. Para 34 also.
Yes.
17.4 has been struck down also. Para 34. Mayor is 17.4 also, but has been struck down.
What happened to this judgment still holds the bill?
There is no SLP against the Lasanaka judgment. I have searched out in the website.
Yes.
May I take your lordship to the compilation page 50, the judgment of the Supreme Court,
Page.
page 50 of the compilation of the judgment.
Pendranath.
Lordship, yes. Lordship, Kalingam. Kasilingam, such as PSG College, page 50.
That Learned Singh has referred to this judgment.
Lordship, that referred. para 20 Lordship. Many of the provision of the act cannot be put into operation only after
Yes.
middle portion para 20. Many of the provision of the act cannot be put into operation only after relevant provision from the prescribed in the rules. In absence of rules, act cannot be enforced.
Para
Para 20 Lordship.
21.
Para 20, 20, page
Yeah.
56. Middle portion Lordship.
Page 66.
Page 56. Secondly, Lordship will find, again, I'd like to list of dates Lordship will find. The rules, National Council of Research Education rules has been, I have given a list of dates Lordship will find.
Yeah, I'm saying yes.
Rules notified on 3/12/97. I have annexed the rule also
Yes.
with the guys notification. Lordship will find page 4 is a guest notification. It was
Page-
notified on 3rd December 1997. So when rule has not been prescribed, rules say who will be the member of the committee, who will inspect the college, who will give the, what will be the fees that has been prescribed in the rule. In the regulation, it has been prescribed this format. And members of the National Council of Research Education has not also been notified, who will be the member of the regional committee. So it is an absurd thing. And Lordship, Allahabad High Court has held, that is an absurd thing. All degree will become invalid all over India, if this is allowed to be stand, Lordship. And that is why, Lordship, honorable single bench of this honorable court, 2 single bench has held degree of the same year, same held to be valid. And that was under silence. So that's my submission, Lordship.
My senior counsel, Mr. D.K. Mishra, my lord, he will make his submission, my lord.
He has already concluded his
He's-
arguments.
My lord, he has concluded, but the reply from to the counter, my lord, my lord, submitted by my friend, my lord, that will be given by senior counsel, Mr. Mishra. Unless, my lord, the judgment of Allahabad High Court as well as the judgment of Rajasthan High Court, my lord, the citation and copies has not been supplied to us, my lord. If we are not,
Your senior was not available, you know, mentioned at the earlier, okay, sir, today we will not be able to.
Well,
When
just
once
now-
he has argued and now you are saying, okay, sir, we need an opportunity, that's not the.
just now he has, my lord, referred to the Allahabad High Court judgment as well as the Rajasthan High Court judgment, my lord.
Counsel, please, this is
My lord,
not
at 2
the,
p.m.
this is not acceptable.
Lordship to take up the matter at 2 p.m., my lord. My friend may be directed to supply the copy of the judgments, my lord. At 2 p.m. he will make his submission, my lord. At 2 p.m., my lord.
At two.
My lord.
Mr. Saike, these things causes inconvenience to the court also. Please keep that in mind.
My lord, if the citations are, my lord, expired, my lord, then
That's.
without giving the copy also, my lord, I can
They have also given
Once we started arguing, either you make a submission at the start. Yes. Now you can't say after half an hour and almost 45 minutes, now you can't say that my senior is not there.
Well, at 2 PM, we'll make a submission, my lord.
At 2.
My lord.
Come at 2.
Copy के
Obliges.
copy के दिखा. At least I should be given to me. One other than the.
Daily list for hearing item 8.
Yes.
My lord, this is in the appeal, my lord. The matter pertains for regularization of the service of the petitioner who was appointed as a tax collector in the Panchayat department. My lord, the
What was the post you were holding?
it was a tax collector.
Tax
Tax
collector.
collector.
In the panchayat.
Panchayat department. Gaon Panchayat, my lord, there are 3 tiers of panchayats. He was working in the Gaon Panchayat, my lord. And my lord, during the pendency of this appeal, my lord, the Gaon Panchayat is abolished, my lord. It is brought on record, my lord. The area is included in a town committee, my lord. And the petitioner subsequently, all the staffs are appointed, transferred to different places. And the petitioner is accordingly accommodated to the Ancholik Panchayat, next tier of the Panchayat, Ancholik Panchayat office, under which the Gaon Panchayat was working.
So
So,
what remains in?
my lord, the post where the petitioner is accommodated presently, my lord, that post is also a sanctioned vacant post, my lord. I have, my lord, annexed by an additional affidavit, my lord. This fact, my lord. For a moment, I got your lordship. Page number 122 of my writ appeal, my lord. Page 122, 122. Additional. Additional.
This is not even his prayer in the writ appeal. This is a new ground that he has raised for the first time.
Regularization or what? Prayer of regularization was there in the writ.
My lord, the regularization prayer is there, but as far as the state of Assam is concerned, my lord, there are 2 types of employees. One is the provincialized employees and one are the PRI employees. So this particular post, my lord, is a provincialized post where the appropriate competent authority to appoint them is the commissioner. So in the year 2017, my lord, 450 vacancies were filled, which included his post of tax collector in the Sonai GP, my lord. So as far as his initial appointment was concerned, he was appointed as a casual worker. His case is governed by another division bench of this honorable court, my lord, Upen Das versus State of Assam. Whereas in light of the judgment passed in Uma Devi, all the casual workers were held eligible for minimum of pay scale as per Jagjit Singh. So right now he is availing that particular benefit as laid down under Upen Das. And Upen Das had clearly ruled out against regularization at the everything.
Then the state came in and. The matter is in Yeah. So 18 and pension and बाहर में जो बैंक so we can do that. But we don't have. We can create a lot of benefits. Okay. Yeah, it's a conception of although we will not be capable, we will be capable. So there will be a lot of something. What makes you feel like the cycle of everybody. Minimum the case to the decade. So now the difference that are doing there now. If there is a regulation, the micro cases but open does the level बाद में है कम से कम भी notification
Yes.
My lord,
Now,
petitioner,
if you are absorbed in some other, how can you seek regularization on this post on which you are initially appointed as a casual labor?
yes, my lord. Yes, my lord. Now, my lord, the present posting, my lord, I have annexed, my lord, order page number 130, my lord. The present posting 130, my lord. How he has been posted in the present place of page 130. Order dated 25/1/18.
It's not given us.
Yes,
25/1/18, my lord.
Not given us.
Additional evidence.
118.
Page number 25/1/18. The page number to 126%. Well, in the interest of public service, Baharul Islam, Borloskor, tax collector come RM, Sunai under Jilla Panchayat should be hereby transferred to Sunai and Churipur in the same capacity.
Casual employed.
Fine.
So, my lord, the initial claim of the petitioner was on the basis of OM, my lord, page number 48. The OM clearly mentioned that, my lord, after satisfying some criteria, my lord, page number 48, clause 2. The OM of 27/6/13 clause 2, my lord, states regarding the regularization of service of casual employees.
Office memorandum.
Office memorandum, my lord, page number 48.
Yes.
My memo of appeal, clause 2, my lord.
Yes.
The state government will now like to take the one-time measure for regularization of those workers as referred to the paragraph 53 of the orders in the Uma Devi's case, Didut MLK case, where exception was carved out to regularize all employees who fulfill the following three conditions. So the conditions, my lord, of Uma Devi, who have working continuously for 10 years, that is 10/4/6, the date of passing of the judgment of Uma Devi, and without the benefit of the court order, who will have been engaged against sanction by the court and who have been.
Mr. Kadir, you are reading from which page?
My page 48, my lord, of my memo of appeal.
Memo of appeal.
Yes. 48.
Page 48, office memorandum. Yes.
Yes, sir. So, my
What
lord,
are you referring to?
yes, my lord, this 48, my lord, as per this OM, petitioners had a claim, my lord, for
Upenda's judgment.
regularization of his
Upenda's
service.
State of Assam versus Upenda's judgment. Recap.
So, my lord, this memorandum was issued, my lord, subject merit regarding, my lord, regularization. Regularization of service of workers, master will and similarly placed workers in pursuance of orders in the Honorable Supreme Court, so and so, and emergency. So, on the basis of this poem,
But the resentment judgment of this court
yes, sir.
in this Upendas is clearly held that such persons are not entitled for this regularization. Only you can get the benefit of minimum pay scale and the other facilities.
Okay.
Then what remains in this matter?
My lord, the order impugned, my lord, the single just order, my lord. There is a specific, my lord, observations that, my lord, the appointment was not, my lord, illegal, not, my lord, in violation of the law. So they are entitled, but, my lord, there is no specific direction for, my lord, regularization. For which,
There
my
is
lord,
no
this,
question of regularization. You are not entitled for regularization. Then how the learned single judge can give a specific direction? Can't be. Anything else?
well, on the basis of this judgment, my lord,
Hmm?
this judgment, covered judgment may be disposed of. My lord. On the basis of, my lord, this covered judgment,
Which
if
judgment?
this, my lord, Upenda's judgment, my lord, disposed of, my lord.
You are getting this now, Upenda's judgment, whatever the held in this Upenda's judgment, you are getting this benefits.
Yes, my lord, yes, my lord.
Then what remains? More than that, you can't claim or even given. That's all. Pass order to.
Action. Disposal. Disposal.
Item 9.
May I please your lordship? Lordship, may I pray to take up this matter some other day? We have some difficulty to the lordship.
Item 10 to 41.
Lordship, in item number 10, Lordship, I am applying for the state of Arunachal Pradesh, Lordship.
State of?
Arunachal Pradesh, Lordship. Here, our learned Advocate General is appearing. Lordship, I will be needing some accommodation for today, Lordship. In item number 10, Lordship.
Sorry, tied up here, all these matters are tied up.
Lordship, Lordship.
matters.
Item 10 is the Arunachal Pradesh, where the Arunachal Pradesh VAT anti-tax act is challenged. Rest of the matters below the Assam anti-tax matters are there.
The provisions are similar,
Well, there is some difference in the Arunachal Pradesh and the Assam below.
but since the matter is connected,
My lord.
which for the state of Assam? The Advocate General is appearing or not? Since the validity of the provision are under challenge. Earlier, Mr. Advocate General was appearing in the matter.
So the earlier, my lord, when I argued some other bench, then it was said the Advocate General will appear, but since my arguments were continuing, he was not there.
Obviously, if the validity is challenged.
Well,
the
certainly.
Advocate of General appears.
Yes, sir. I appear in the Arunachal matter. There is one Arunachal matter where the Arunachal Act is under challenge. And there, my lord, I would pay for a little accommodation. This is a huge subject. I need to go into it. Suddenly, matter has come up suddenly. This was filed way before I had joined. In any case, I don't see the petitioners also.
The earlier occasion, the appellants were relying on this Jindal Stainless Steel Limited. The petitioners are relying on so and so, and some time was granted to meet that argument. 9 judges bench judgment. You're relying on that judgment?
But I'm relying on the observations made in the Jindal and thereafter the points which had been left out. For the Jindal Stainless, after that, the matter went to again to the regular bench of the Supreme Court. And Supreme Court 2-3 issues said that these issues will not decide. It is for the High Court to decide on the basis of the facts.
In that Honorable Justice Sikri's judgment.
Well, that is the judgment of 9. Well, this is the judgment of,
Majority judgment is by
no, I'm not on majority.
Jindal.
The state of Assam and others. versus
My lord,
Chotabai-
my lord,
Chotabai JP Tech 4.
my lord. In that case, my lord, when the matters came up to give effect to the 9 bench judgment, the court found that 2-3 issues are there which cannot be decided.
We may also mention that at this stage, when the matters were argued before the 9 judges, certain other aspects were also primarily 3 kinds of issues were taken by the SSC which are following so and so.
My lord.
The 9 judges bench, by answering the reference, deemed it appropriate to leave these questions to be agitated before the regular bench.
My lord.
This is how these matters are posted before the bench. It is agreed that the aforesaid issues are the main issues to be decided.
The lordship is page 9, my lord, of the order. Of the Chota Bai, my lord.
Yes, 9.
Page 9, my lord. Before this,
I have referred to page 9 only. We
Milord,
may also mention. in
you may
fact,
also mention that at this stage, when the matters were argued before the Nigeria bench, certain other aspects were also argued. Similarly, these kinds of issues were taken up by SSC which are to be following effect. These are the issues which are there.
Yes.
Thereafter, the court said, Milord. The next page, Milord.
Yes.
Second paragraph, during the hearing of the arguments, counsels of both the sides admitted that since the main challenge in the requisition, which were filed by the requisitioner before the High Court, was premeditated on the law laid down by the Constitution bench in the Atiabari, and the High Court essentially confined the discussion only on the compulsory tax theory as propounded by the aforesaid judgment. So the High Court looked into the issues as only keeping in mind the principles propounded by the aforesaid judgment and decided to whether the tax imposed by the particular state is compensatory in nature or not. Thus, when other issues are to be dealt with, as indicated above, we find that in many cases there is no adequate factual foundation and there is no discussion in the improvement as well. It is therefore agreed by the counsel for both the sides that in the absence thereof, it may not be possible for the court to decide the issue. According to us, in this factual scenario, appropriate course of action should be to submit the applicant to file fresh petition in the so-and-so relating to the aforesaid issues with necessary factual background for any other petitioner statutory issues which arise for consideration. So, the court gave liberty that those issues will be raised before the High Court. Milord. Mainly three issues are
Who is appearing for the state of Assam? Two states are involved, Arunachal and Assam.
Yes, ma'am.
You are appearing.
Yes, I'm not asking. Lordship, I'm appearing, and learned advocate general will be attesting your lordship.
When?
Lordship may fix it up on either on 26th or 27th or 28th.
Mr. Saraf, but I have no objection. But the main three issues are there, will picture of consideration.
We have to hear them.
Well, certainly, there is no dispute about it.
Give me some, should have informed them. Yes,
No,
whether we-
Lordship, he may start it, learned.
Start, we don't want to do it in piecemeal. We want to hear and conclude it in a one hearing.
This is the third time the matter is coming up again and again. So this time, once it is there in one go, it can be finished.
It may finish, but otherwise then there are so many things we have to keep the, again.
Absolutely, Lord, absolutely.
Yes, Mr. Reji, please argue it out.
26th is fine.
We'll fix it on March, any date. Yes.
19th.
Your convenient date for March.
19th.
But if it, March 21st,
21st.
So if it 21st March, then it will be convenient, because
21st March.
Thursday, Lord.
Lordship, can I ask the advocate general and communicate the date, Lordship, within 1 or 2 minutes?
You please communicate between yourself and ask for a date, we'll give that. Whatever agreed date between all of you, Communicate to the court master. Will do.
I have no difficulty, only 3 days, my lord, from 18th, 19th, 20th, I'm not there, that's why, my lord, any other date, my lord, I'm able to pay.
You please have a,
My lord, certainly, my lord.
get yourself decided.
If he has got some critics, others otherwise therefore.
That's why only you please. Get yourself, resolve this matter regarding the
All the matters, my lord, item 41.
list on so and so as per the. For the joint request, list these matters on so and so.
I'm obliged, no?
Item 43.
Lordship, kindly pass over the matter for the day, Lordship. Due to some personal difficulties of my senior could not appear before this honorable.
Pass over for the day.
Lordship.
Yeah.
Item 45.
Wait, please, lordship. Please. Lordship, aggrieved by the order dated 11/4/2019, this appeal has been preferred, my lord. The order at page 62, my lords. 62, the last page of my application. No, the last page.
You agreed by only this
No, my lord,
cost.
cost, my lord.
And
Only on the part of the cost, my lord. As
you are agreed by that.
my lord, as an establishment, we do not fall under the definitions at 2K of the 1995 Act. And that was what was considered in this matter. And this, when this case was filed in the year 2011, that 95 Act was prevalent, my lords. So my entire basis of argument is that establishment, my private establishment does not fall under the definition. If I may, my lord.
No, after implementation of the new act, now you are compliant with all the facilities.
Lordship,
You are equipped with the facilities
Yes,
for
yes,
the
yes.
differently able persons or this. Persons suffering from cerebral, you are now doing it, everything.
lordship.
Yes, ma'am. Well, there was some misunderstanding in regard to our reception at the time when initially this matter arose. But now, so far the gym facilities are concerned, it is also friendly to the people with special abilities, my lord. It's not that. And so far, the new act are concerned, my lord, everyone has to now follow it because the government have also filed a detailed affidavit of the steps taken. It's not that the government is not doing anything, but after this case, at least government has started the process. That's one positive outcome of this proceedings.
Ultimately, the cost, you are a big company cost is given to the
No, my lord,
State Legal Services Authority of the.
my lord, the mandatory is something different and something given voluntarily. It's not that we are not doing anything for the charitable purpose, my family and all. We are doing, even when my mother died, she gave a list of around 75 persons whom we have to give them artificial limbs and all. Those things I don't want to bring it on record, but mandatory and, my lord, something which is given directly and out of, that's we have given more than the amount that is there. That's the only issue so far we are concerned, because that is.
You have not preferred any appeal.
But we have not prepared. In fact, we have
Deposited that money. with-
Yes, yes, we have deposited. We have complied with that.
Order to bring order.
What is your main contention?
My lord, I was only the private entity, the owner of the Gold Gym, my lord.
What the referring, Mr. Consul was referring that they were not falling in that definition of what?
Establishment. Under the old act, my lord, the private establishment was not included. Under the new act, my lord, which is always retrospective, that now it includes the private establishment also, because the restaurant, suppose a person goes to the restaurant, they should have a ramp to take the wheelchair inside.
Mr. Kaur, is your client agree with the amount of 50,000 or any stigma attached to the order?
Stigma.
If we clarify that the stigma, the order will be denuded of the stigma, then what is the problem?
Well, the problem is that so far the fault that is trying to be attributed to us, there was no fault on us. And to submit with utmost respect, the problem in the Northeast, what we are facing as a gym owner, is that we don't get sufficient persons who are trained to handle this type of cases, my lord. That's the main problem. We have now, but we are training in-house also to how to approach these patients. But it is always a learning experience. So far, my lord, that amount is concerned, if your lordships directs, then everybody has to pay. But for the reason that has been ultimately the conclusion on the basis of which that cost was awarded, I think that is.
You read those conclusions, let us see. What are the observations?
No, your lordship will first look into the definition under the old act first.
Okay, yes.
This is the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act 1995. Sorry. I have one extra copy, or otherwise I can airdrop to your lordship's mail account. I knew it today. One to print out quotation. This is the old one,
1995, yeah.
99. Now your lordship will see the definition under K, 2K. New to them. So print out this one. For my.
Yes.
But I'll give I have just a printout to show the comparison, madam.
2K establishment.
Yes.
Yes.
2K establishment means a corporation established by or under a central, provincial or state act, or an authority or a body owned or controlled or aided by the government or a local authority or a government company as defined in section 617 of the Companies Act 1956 and includes departments of a government. We don't receive any grant from the government, no aid, nothing. Then now the new is that 2-1, it has become now 2I. Establishment includes a government establishment and private establishment. That comparison chart your lordship can see. 2I is now has been amended to include a government establishment and private establishment. And private establishment has been defined under the new act under section 2(5). So under the new act, your lordship will find 2(5) has changed, 2B has changed. Then in the next page, your lordship will find even public building has now been defined under 2W. Then under section 25, they have included healthcare. Then under section 41, even the access to transport is now, because your lordship has seen probably in the airports and all the buses, now they have a tray which they pulled it out from the door to help the people with special abilities to get inside. We are only a private gym, madam. That was.
What are the observations of the learned?
Yes, ma'am.
user by which you are?
Yes, your lordship will find, first look into, the order starts at page 54. The facts are given at 4 and 5. Then our contentions have been recorded at paragraph number 9, my lord.
4 and 5 para.
The 4 and 5 is the facts of the case. The 4 and 5. Paragraph number 4 and 5 at page 55.
Yes.
This his grievance of the petitioner.
Yes.
Then paragraph 9 was our preliminary objection before the learned single judge.
Simply raise the question that
Yes,
the appellants or the respondent in that petition
yes,
does not discharge any public duty or function.
yes, ma'am.
And therefore, within Article 12, within the meaning of Article 12 cannot be termed as a state or other authority.
Yes, ma'am. And
No specific regarding this that.
we have denied those allegations and all. Because initially, on the question of maintainability, when we raised up, this entire petition was disposed of. Your lordship will again see paragraph number 20 at page 60.
Yes.
Then court concluded in paragraph number 24. And at 25, the cost has. I'm sure, my lord, this 50,000, if your lordship directs, my friend will never, petitioner, the appellant will never refuse. They are one of the most philanthropic family in the state of Assam. Those things I can always assure lordship.
There are observations against you.
My lord, those observations, my lord, are only unfounded. These are all disputed.
Where are that?
My lord, so far these observations are concerned, my lord, it was only when we first raised a preliminary objection on the technical point of law that we are not amenable to the.
Show us where the learned single judge has made any remarks or observations against the appellants.
My lord, your lordship.
They are not doing it or whatever.
Yeah, paragraph number 25, your lordship will
Paragraph
find.
number 25.
Yes.
Yes.
Second line, respondent number 6. Though a private entity has also a duty to ensure that its facilities are friendly to the different able. Our facilities are friendly able, but there are certain risks, my lord, in a gym when weights are being pulled and the gentleman moves around with a wheelchair inside the gym premises, or he has to be treated differently. And problem with the Northeast is that I'm not talking about only our gym. We don't get sufficient amount of trainers who are specially trained to handle this kind of persons. Yeah, this is 2011, my lord. And he was never denied admission inside the premises. He has some grievance, my lord. And if, of course, this is.
State affidavit, that's all. If your lordship looks into the state affidavit, now they have filed a voluminous affidavit of the steps taken by them after this case. At least that is the one positive outcome of this proceedings. And this incident occurred in 2011. Now, of course, in 2024, much has changed, madam.
Yes.
I mean, quickly allow to address your lordship. Lordships will perhaps note that the Vienna Convention on the Law of Treaties 1969 very clearly states that the state parties who have signed the treaty are naturally bound by the purposes or the implications of that particular treaty, and they are obliged to make their laws compatible to those that treaty allows. Now, the United Nations Convention on the Rights of Persons with Disabilities, which is called the UNCRPD in short, was brought into force sometime during the year 2005, and India became a signatory to that treaty in the year 2007. Lordships will kindly take up the memo of appeal. In our writ petition at page 28, we had categorically stated the provisions of the UNCRPD, according to which private entities, even in 2007, were required to take certain actions. And that was duly quoted by us in the writ petition. Now, my learned friend, while reverting to the allegations in the writ petition, in his own wisdom, did not deem it fit to deny any of these provisions of law or come up with any other defense. The only thing which they stated in their affidavit in opposition at that particular point of time was that they are not a state within Article 12. Now, your lordship will note that the learned single judge at paragraph 12 and 13 of the judgment, of the impugn judgment, if I may just take your lordships at page 57.
Yes.
Paragraph 12, your lordships. Over a period of time, the conceptual understanding of the rights of persons with disabilities has become more and more clear, and there has been worldwide change in approach to handle issues concerning persons with disabilities. United Nations General Assembly adopted its Convention on the Rights of Persons with Disabilities on 13/12/2006. Amongst the various principles laid down by the Convention for Empowerment of Persons with Disabilities, full and effective participation and inclusion in society, as well as accessibility of persons with disabilities, were the leading ones. India was a signatory to the said convention, and India ratified the convention on 1/10/2007. I just pause here for a moment, Your Lordship. The incident is of 2011. So on 2007, we were already a signatory to this particular convention, Your Lordships. Now, paragraph 13, to give effect to the UNCRPD and for matters connected therewith to or incidental thereto, the Rights of Persons with Disabilities Act 2016 was enacted, which was replaced in the 1995 Act. Lordships, now, if I may just pause here for a moment, considering the fact that we were already a signatory to that convention, and if there was any lapse in us bringing the law into force till 2016, can my learned friends say that they were not obligated by those things?
Ma'am, this is not the case.
Lordship.
We are concerned about that.
Lordship.
Yes, he was signatory to that convention
Lordship.
and ratified the same on
Correct.
1/10/2007.
Lordship.
Thereafter, any direction or instructions or guidelines were issued by the state
Correct.
to the private entities that you have to maintain this. Is
Lordship.
there any provision?
Lordship, there was the judgment of the Honorable Apex Court of 2016, Jija Ghosh versus Union of India. If I may just place those provisions before your lordships. Now, in that particular case, this was a person also suffering from having cerebral palsy, and she was deboarded from an aircraft which was belonging to some particular airline. Now, in that case, what happened, your lordships? Naturally, the airline was privately owned. Duly taking note of the fact that it is a private entity, the Honorable Apex Court, in its own wisdom, imposed a cost of rupees 10 lakhs on the private airlines to be paid to the petitioner.
In the year 2016.
Yes, your lordships. But the fact remains that incident also had occurred a long time back. That incident also, if I'm not mistaken, was sometime of 2012, your lordships. So in the fact that, and the Honorable Single Judge judgment has come in 2019. The matter was pending before this honorable court. It was open to my learned friend to have denied any of the allegations which we had made or to come up with any particular issue. This aspect was duly brought to the note of the Honorable Single Judge, and only taking due note of the judgment in paragraph 17, the learned single judge takes due note of the Jija Ghosh judgment
Yes.
And then comes to the finding that, and your lordship, my only submission before your lordship is that my learned friend is not aggrieved by any of the observations of the learned single judge against them.
No.
Directly into the code, no? 2010, so it is not counted.
That's correct.
Rafi to the. What is
Yes.
Lordship, that is my humble prayer that the submission before your lordship, that
Quarrel about that.
no, there's no lordship, and the only grievance in this, if my learned friend is saying that this the appellant before your lordships is as philanthropic as it is, then this appeal ought not to have been filed, because it is not it is the quantum of money
Certainly,
has not been.
they are
Lordships,
aggrieved by since what they feel, some indiction is there on this appellants by the learned single judge, therefore they have approached this that no.
but his prayer is not for that, your lordships. His prayer is
Prayer,
only for
whatever, now he is
if your
confined-
lordships will see
he
the
is
prayer.
confined- Now he has confined his prayer only up to that.
No, the main prayer, there is no prayer for any other expansion of remarks or any other, your lordship will find the
Making
prayer.
the Oral prayer, we can't
Lordships.
consider it.
Lordship,
Now-
lordship, yeah, that is of course your lordship's discretion. But my only submission was that his prayer in the main appellee, when he had filed it, was only for that quantum. And it is not an amount of money which has been allowed to be given to me personally.
Oh,
It
that's
was to
fine.
be, it was to be granted to an NGO, your lordship.
No doubt about
In your lordship's own wisdom,
it. They are ready to pay that.
My lord,
if they
So,
are, lordship, why not?
2010 for SCC, my lord, 2378 was directly on this issue that whether private establishment will be included or not. That is the judgment of the Honorable Supreme Court, and it says that under this Disabilities Act earlier, private establishment has been excluded, my lord. Your lordship will find in the paragraph number 32, 32, 34.
Read.
My 32, my lord, your lordship will, we should not lose sight of the fact that the wards corporation established by under central, provincial or state is a term used in several enactments intended to convey a standard meaning. It is not a term which has any special significance or meaning in the context of Disabilities Act or any other socio-economic legislation. It is a term used in various enactments to refer to statutory corporation as contrasted from non-statutory companies. Any interpretation of the said term to include private sector will not only amount to overruling the clear enunciation in Dhanwa, which had held at a field for nearly 3 decades, but more importantly, lead to the ensure of distinction. Then your lordship will see paragraph number 34. The last line, we do not propose to transport sector as the issue does not arise. Further, the use of the words within the limits of the economy makes it virtually directly be that as bait. What has happened in Jija Ghosh case, I also have. Jija Ghosh case was in relation to transportation in the aircraft. So they had refused it. That's why court went beyond, the Supreme Court has exercised its powers under 142 and said that this should not have been done. That's why your lordship has seen in the airport, now we have those Indigos without staircase and the bus tilts on the one side to allow the person with special disabilities to get inside. That has happened after Jija Ghosh case. So far, this case is concerned, my lord, I'll just, if the order is not stigmatic, then these disparaging remarks are not against us. I think my friend will not refuse to pay 50,000 to.
Mr. Concept, please.
Yes.
Your respondent number 6 before the learned single judge.
Yes, my lord.
What was your affidavit before the?
We just, because the case was at the motion stage, we just filed a short affidavit, taking the issue of mental ability and denying the
Learned
allegation.
single judge has made an observation in para number 21 of the impugned judgment.
Yes. Yes.
The
It is for the,
affidavit of the respondent.
Yes, yes, yes.
Quite certain.
There.
The
Yes,
respondent
just a
number
moment.
6 could have also have filed a better affidavit rather than highlighting.
Yes.
Only its private character and contending that the writ petition is not made.
My lord, on day one, my lord, we always take a linkability issue. If that doesn't succeed, then we always come out with a detailed affidavit, my lord.
Lordship, 8 years. The matter was pending.
Then your lordship will see the next paragraph at page 61. Paragraph number 23, my lord. My lord, your lordship will kindly see paragraph number 22 and 23. Instead of ridiculing me in the court, my lord, that I have not done this and that, it's better, my lord, my learned friend will stick to paragraph number 22 and 23 at page 61. That's what, as a officer of the court, I would be happy to see it. I can always advise my friend, the petitioner, to take proper steps to sanitize his staff and all. Because basically, the grievance of the writ petitioner, your lordship will find in his representation at page 38. What was his grievance, my lord? Your lordship will see why he was.
Yes, Mr. Kaur. Just a minute.
Yes. Page 26. Okay.
You have not deposited the cost till date.
No, my lord, there's a stay order operating.
Okay, then in what time you will deposit the same?
Your lordship will remove that stigmatic and all as my, those.
What we are asking, in what time you will deposit the same?
Why, your, well, 50,000, I can deposit anytime your lordship direct. That's not an issue. Well, your lordship will see the main grievance of the writ petitioner at page
The council can
39.
deposit it if necessary.
Then.
Well, that, because
once
of
it
this
gets
thing.
deposited, then it's okay.
Yes, well. Your lordship will kindly see for a moment what we did as a gym owner. Your lordship will see the allegation at page 39.
Yeah.
Because this
Mr.
gentleman.
Kaur, it appears that the purpose of the order is not so much the indictment of your client
Yes, ma'am.
as it is to generate an awareness.
Yes, ma'am.
Right?
Yes, ma'am.
So everything has a purpose.
Yes, ma'am.
Everything cannot be approached in a strictly legalistic
Yes, ma'am.
sense.
Yes, ma'am.
So we are trying to see if a balanced approach is
Yes.
possible. My lord, the Honorable Chief Justice is making a query. By what date can you deposit the 50,000 rupees?
Any day, my lord, your lordship may direct, but that's not an issue. Only thing is that those, because they should not ridicule us and publish in the newspaper tomorrow that Gold Gym has been awarded 50,000 cost by the High Court for not being friendly to the disabled. That's where our fear is, my lord.
Mr. Counsel, the newspaper may publish any type of news, even though positive news, they can pose it as a negative news. But it's okay. We have no control over that.
Yes. No,
But
but your
certainly
lordship's
I have-
observation will protect me, ma'am.
We'll take care of.
Yes, ma'am.
We'll take-
Yes. Your lordship will, and your lordship, I think in the order, it's asked to be paid to Shishu Sharati. We'll pay it before the Registrar General of the High Court.
No, why not? Do
Yes,
direct
ma'am.
to
Your
Shishu
lordship,
Sharati.
direct, we'll deposit that 50.
Direct to Shishu Sati, what's the problem in that?
Shishu Sharati by quota, sir.
Or is it that you would like to pay a little more?
I've been doing.
Little.
My lord,
little
here,
more.
my lord, we are doing. I have learned many good things from them, my lord. My lord. He is a Jain, my lord. I have learned many things from the Jain people, my lord. They are very philanthropic, my lord. Unlike us at many times.
We'll pass it.
Yes.
Deeply obliged.
Item 47.
Yes. Yes.
Well, the issue here relates to the power of the election, district election officers, or for that matter, the chief election commissioner to draft the employees of a particular institution or an office for a particular election. Well, here, the Assam University Teachers Association is before your lordships. This is Central University, Autonomous Central University at Silchar, established in the year 1991. The teaching staff constitutes of professors, associate professors, and the assistant professor. The association, it has about 310 members. And to the extent of 270 at a time drafted for election duties. That's how the grievance arises. Now, under 159, Representation of People's Act 51, power is granted to draft such number of officers. It is the chief electoral officer of the state who is empowered to draft. And he, after drafting, places it at the disposal of the district election officer, and he engages them, appoints them. Here, the power has been exercised by the district election officer himself, and that too arbitrary. My grievance is that does Section 159 provides an uncontrolled, unlimited, absolute power, unbridled power to draft any number of stuff for a particular election, including Panchayat election here. In 13 and 18, we were drafted for Panchayat election also. Is it not infringing the Article 14? Unreasonableness? The whole action is arbitrary and unreasonable. It doesn't give that much of power. Thus, absolute power is unconceivable to our constitution. Therefore, we have come that in the last assembly election in 2021, Lordship will kindly come to my statement at paragraph 13. Lordship will find the whole data there.
Reply to the-
Before that, I will take the honorable court. Lordship will see in page number 13, paragraph 12, I have stated that on 2nd March 2021, general election in the state was declared by the governor. That paragraph 12, my lord. Then please come to the next para. I will read out. The petitioner humbly states that the respondent authorities, in view of the ensuing Assam Assembly election of 2021, issued the following. An order dated 31/1/2021 bearing memo number such and such was issued by district election officer directing 119 assistant professor, development officers and assistant teachers of the Assam University to be appointed as assembly level master trainers for imparting training to the polling personnel and organizing EVM awareness program in connection with the Assam Assembly election. 2, a training call letter dated 5/3/2021 bearing number so-and-so was issued by the district election officer, Kasar Silsar, Assam, to the Vice Chancellor of Assam University, Assam, for 256 polling officers. 256 polling officers were taken from the university. A final appointment letter dated 5/3/2021 bearing number such was issued by the district election officer to the Registrar Assam University for drafting 248 teachers staff of the Assam University. A letter bearing number so-and-so dated 19/3/2021 issued by the Additional Deputy Commissioner, Kasar, in charge Videography Cell, Assembly Election 2021, whereby again 70 of the teaching staff, 19 from Assam University, were drafted for capturing the video footage of absentee voters. For that also we were used in Assam Assembly Election 2021. An order dated 19/3/2021 issued by Additional Deputy Commissioner Kasar, in charge Training and Awareness Cell, Assembly Election 2011, whereby 17 Assembly Level Master Trainers, ALMTS, Assembly Level Master Trainers, 9 from Assam University were drafted for imparting finalization programs. Familiarization programs of EVM, VVPAT, and other poll procedures. 6, an order dated 23/2021 was issued by the Additional Deputy Commissioner Kasar, Personal Cell, Assembly Election 21. 1 person from the university was drafted as ALMT. 2 orders dated 27/3/21 was issued by the Additional Deputy Commissioner Kasar, in charge Training Awareness Cell, whereby overall 38 teaching staff of Assam universities has been assigned duties of Assembly Level Master Trainers. An order dated 8/4/2021 bearing number so-and-so has been issued by the Additional Deputy Commissioner Kasar, in charge Training and Awareness Cell, whereby 69 teaching staff, 33 from AU, Assam University, who were requisitioned as Assembly Level Master Trainers are relieved from the Training and Awareness call and placed under the disposal of the Election Personnel Cell. This batch of teachers has been on election duty for more than a month now. That time they were on duty for more than a month. Orders dated 17/4/2021 issued by the District Election Commissioner and District Election Officer, Silsar, whereby more than 70 teaching staff of the Assam University has been drafted as micro observers after they have been done with their duties as presiding officers.
You are challenging the validity of section 197.
159.
159, I'm sorry.
Yes,
159.
159, kindly see.
Yes.
My lord. Yeah. What's it? My lord. In this page, Universal's publication, page 118.
118, yes.
Yes.
Staff of certain
Staff of certain authorities to be made available for election work. The authority is specified in subsection 2, cell, when so requested by a regional commissioner appointed under clause 4 of section 3 to article 324, or the chief electoral officer of the state make available to any returning officer such staff as may be necessary for the performance of any duties in connection with an election. Now, the following shall be the authorities for the purpose of subsection 1, namely, every local authority, every university established or incorporated by or under a central provincial or state act. A government company as defined in section 17 of the Companies Act 56, any other institution concerned or undertaking which is established by or under a central, provincial or state act, or which is controlled or financed wholly or substantially by fund provided directly or indirectly by the central government or a state government.
How it is related to Article 324?
324.
Yes.
324 gives the power
Oh,
under which this has been made. But here, my lord, kindly see, this has come, 159 has come after amendment. After the decision which was rendered in State Bank of India, that case. Nahi, my lord, I will get it. This has been done, my lord, this was amended after the decision of the apex court. And this is how now this 1, 2, 3, 4 has come. Now here, kindly see, it has said every university has been mentioned. That means staff of the university can also be requisitioned for election duty. Now, the question is whether that is a power given to draft almost any number of members of that university, which will render the university
that may.
unfunctional.
Maybe the answer on the part of the university that they are requisitioning and so many number of staff that it may hamper their educational activities. But certainly that will not give rise to the that will not strengthen your argument that section 129 is violative of Article 324, sir.
324 as well as Article 14. My whole ground is that this is unreasonable power,
So unreasonable.
uncontrolled power.
Then how this 159 is unconstitutional, sir?
Well, anything which goes to provide arbitrary power is illegal, sir, unconstitutional. That is my argument, limited to that extent.
Power, there is no conferment of arbitrary power. Arbitrariness is an exercise of power.
My lord, I only submit to your lordship, right? Here lies the question now. Power has been granted, but definitely not an arbitrary power.
That's no doubt.
So for the authorities,
If any action of the respondents is arbitrary, you can very well challenge in a separate set of proceedings, not in section challenging the validity of the provision itself, sir.
my lord, my sole submission
Any
is
arbitrary action.
arbitrary
challenge
action can be
separately.
challenged. Yes. My lord, the question is, when this particular provision is used, to do something which has infringes the whole power given under 324. The power 324 was not given to abuse.
No doubt about it.
This power was not given to abuse.
No doubt about it.
Therefore, authorities are to bear in mind, and because here it is not specified how much or what quantity of officers can be drafted in a particular election of these universities. Therefore, it is arbitrary. There ought to have been.
Lunch.
May please. Millet, basically, I have approached this division bench on the ground that section 159(2)(2), which says the university, staff of the university. That staff of the university leaves the scope. It has, having not been provided clearly that the teaching staff and to what quantity, it can be requisitions. It is arbitrary in nature, the power which infringes the Article 14. And this goes against the very purport of Article 324, which gives the power, but not an arbitrary power. To that extent, my lord, I will just place the decision of Mohendra Singh Gill, what the apex court has considered while deciding Mohendra Singh Gill's case, 1978 1 SCC 404. This is one. (405) Lordship will find Constitution Bench decision 1971 SSC 405. Paragraph 38, Lordship may state will come to. Article 324, Lordship got it, my lord. Paragraph 38.
38.
Article 324, which we have set out earlier, is a plenary provision vesting the whole responsibility for national and state election, and therefore the necessary powers to discharge the function. It is true that Article 324 has to be read in the light of the constitutional scheme and the Article 150 Act and the 1951 Act. Sri Rao is right to the extent he insists that if competent legislation is enacted as visualized in Article 327, the Commission cannot shake itself free from the enacted prescriptions. After all, as Matthew J. has observed in Indira Gandhi's case, in the opinion of some of the judges constituting the majority in Bharati's case, rule of law is the basic structure of the Constitution apart from democracy. The rule of law postulates the pervasiveness of the spirit of law throughout the whole range of government in the sense of excluding arbitrary official action in any sphere. And the Supreme Court of and the supremacy of valid law over the Commission argues itself. No one is an imperium in imperio in our constitutional order. It is reasonable to hold that the Commissioner cannot defy the law armed by Article 324. Likewise, his functions are subject to the norms of fairness and he cannot act arbitrarily. Unchecked power is alien to our system. Even so, situations may arise, 39, which enacted law has not provided for. Legislators are not prophets, but pragmatists. Though it is that the Constitution has made comprehensive provision in Article 324 to take care of surprise situations. That power itself has to be exercised not mindlessly, nor malafide, not arbitrarily, nor with partiality, but it keeping with guidelines of the rule of law and not stultifying the presidential notification nor existing legislation. More is not necessary to specify, less is insufficient to leave unsaid. Article 325, in our view, operates in areas left unoccupied by legislation, and the words superintendent in areas, superintendent's direction and control, as well as conduct of all elections are the broadest terms. Myriad maybes, too mystic to be precisely precized, may call for prompt action to reach the goal and free and fair election. It has been argued that this will create a constitutional despot beyond the pale of accountability, a Frankenstein's monster who may manipulate the system into elected despotism. Instances of such phenomena are the tears of history. To that, the resort may be that the judicial branch at the appropriate stage, which with the potential of its benign power and within the leading strings of legal guidelines, can call the bluff, quash the action and bring order into the process. Whether we make a trump or travesty of democracy depends on the man and as much as on the great national pursuit. Secondly, when a high functionary like the commissioner is vested with wide powers, the law expects him to act fairly and legally. Article 324 is geared to the accompaniment of free and fair elections expeditiously. Moreover, as held in Virendra and Harisankar, discretion vested in a high functionary may be reasonably trusted to be used properly, not perversely. If it is misused, certainly the court has power to strike down the act. This is well established and does not need further case law confirmation. Moreover, it is useful to remember the warning of Chandrasud J. Quote, but the electorate lives in the hope that a sacred power will not so flagrantly be abused, and the moving finger of history warns of the consequences that inevitably flow when absolute power has corrupted absolutely. The fear of perversion is no test of power. 40. The learned additional Solicitor General brought to our notice rulings of this court and of the High Court, which have held that Article 324 was a plenary power which embedded the Commission to act even in the absence of specific legislation, though not contrary to valid legislation. Ordering a repoll for a whole constituency under compulsion of circumstances may be directed for the conduct of elections and can be saved by Article 324, provided it is bona fide necessary for the vindication of the free verdict of the electorate and the abandonment of the previous role was because it failed to achieve that goal. While we repeal the Rao's broadside attack on Article 324 as confined to what the Act has conferred, we concede that even Article 324 does not exalt the Commission into a law into itself. Broad authority does not bar scrutiny into specific validity of the particular order. Now, my lord, I'll here take your lordship again to paragraph 48. My lord. Once we understand the soul of the rule as fair play in action, and it is so, we must hold that it extends to both the fields. After all, administrative power in a democratic setup is not allergic to fairness in action, and discretionary executive justice cannot degenerate into unilateral injustice. Nor is there ground to be frightened of delay, inconvenience, and expense if natural justice gains access. For fairness itself is a flexible, pragmatic, and relative concept, not a rigid, realistic, or sophisticated abstraction. Ritualistic. It is not a bull in a china song, nor a bee in one's bonnet. Its essence is good conscience in a given situation, nothing more, nothing less. The exceptions to the rules of natural justice are a misnomer, or rather are but a shorthand shorthand form of expressing the idea that in those exclusionary cases, nothing unfair can be inferred by not affording an opportunity to present or meet a case. Textbook excerpts and ratio from rulings can be heaped, but they all converge to the same point that audio alter partem is the justice of the law. Without, of course, making law lifeless, absurd, stultifying, self-defeating, or plainly contrary to the common sense of the situation. Now, my lord, lastly, I will take the lordship to 53. Paragraph 53. How the court has considered Rees versus Baldwin is a leading case. Paragraph 53. ma'am.
Yes.
Reed versus Baldwin is a leading case which restored light to an area benighted by the narrow conceptualism of the previous decade. To borrow Professor Clark's expression, good administration demands fair play in action, and this simple consideratum in the format of natural justice. Yeah, my lord, this is regarding natural justice, we may skip that, my lord, not necessary. It was a hate of the question, fair play into the reasonableness to hate court is like that. One marks actually. Ahora. Okay. Mark what? Just a minute, my lord. Another paragraph of the court of law, tomorrow mark question, belak kita was. Question itu unusual luminous na ho. Another paragraph of the misstolen.
Yes.
Let the, so therefore, by referring to paragraph 39, 34 and 39, as we have read it, my lord, here, it must stand the test of reasonableness. That is, precisely, it cannot flout the constitutional scheme. By now, My lord, even right to education is a fundamental right flowing from Article 21. Here, the whole educational institution at times brought to a halt because of large scale drafting of its employees. Though it is not specified, staff means two kinds of staff, teaching, non-teaching. Both are included now. Teaching, non-teaching, all are taken, but mostly the teaching staff is taken, drafted for every election, including panchayat election, for polling duties, then for micro observers, even for collecting votes from the interior places, videography, doing videography, all that. Therefore, this is an arbitrary action on the part of the authorities. They must balance. Democratic function and the education institution must go hand in hand. They cannot do something which will totally frustrate the activities of an educational institution. This only not affects my career. As a teacher, we have to maintain, we have to perform very tight schedule. Our duties are specified. Hours are specified. Weekly semester system, my lord, weekly, at least how every day we have to work from 10 to 5, even beyond, because we are whole-time workers, full-time. Research activities, teaching and all that. We are experts in the respective subjects. So they are used as an expert to guide their research students. Their availability within the campus 24 hours is a requirement. That is why they are all stationed within the campus.
Concern, what you have argued that it may cause or frustrate the working of the university and all. This argument is available to each and every organization, department of the state also. Even the education department may say that it may frustrate the education. The Panchayat Raj department may say that the employees are assigned to the election duties, their work is also going to be affected. The banks, the insurance company, everyone can say.
Lord, Lordship is right that way. Everybody can claim it. So therefore, my argument was they have to balance it. After all, the democratic function, holding of election is also democratic function, very important democratic function.
Maybe.
Nonetheless, other
Maybe that's right,
functions
but
must go hand in hand.
how it will make this section 140, this 149 unconstitutional?
My lord, before I answer to your lordship's question, may I place another decision of the apex court?
Fine.
Where the education was the subject matter.
The
Education was the subject matter, whether from education institutions, though school was the party there, the St. Mary's case. How the apex court considered, kindly have a look on this. This is regarding reported in 2008 to SCC 390. Conduct of relation vis-a-vis utilizing the services of the schools, teachers and all, how the apex court considered. Two thousand eight to SCC 390. Here also, Lordship may kindly first look to paragraph 3, page 392. Short campus defects has been said. Respond number 1 is an unaided school. It is governed by the provisions of the Delhi School Education Act 1973 and the rules framed thereunder. It filed a writ petition in the public interest questioning the action of the appellant and respond number 2 to 5 herein as regards utilizing the services of the teachers of the government schools for various purposes during school timings. As a result whereof the students reading in the said schools are deprived of obtaining instructions from their teachers during such period. In the writ petition, it was pointed out that the absence of teachers occurs due to their deployment for non-educational purposes, and as the teaching and administrative staff of these schools have been used by the state agencies as well as the appellant herein for various other duties outside the school during the school hours, including polling duties to general election to Lok Sabha, polling duties to general election to Legislative Assembly, polling duties to MCD elections, Gurudwara elections, revision of polling list, pulse polio drive, preparation of census list, surveys and malaria population, etc. Then the act has been, poor Lordship may also see, the act and the rules framed thereunder, which governs the field, mandate that all the schools in Delhi have to function for a minimum of 210 days in a year. It was pointed out that although the extent of the period differed, the teachers were asked to perform polling duties for a few months and also census duties for considerable period. The writ petition highlighted that absence of teachers from the school for a long time resulted in unfinished courses, high dropout rates, poor results, and inability to compete in open examinations such as medicine, engineering, etc., and or to get admission in other prestigious or professional colleges. It was contended that an informal survey conducted by the petitioner therein demonstrated that about 9 lakh students had enrolled themselves in class 1 to the school run by Municipal Corporation of Delhi, but only 50,000 of them appeared in the secondary education. Then municipality proportion plea was taken. And Lordship may skip over. This is the backdrop of the challenge. Now. Yeah,
just a minute, Mr. Mark.
Malu.
Yes.
Yes.
Yes,
My lord, kindly, I was referring to paragraph 13 of the decision,
1-3,
1-3.
fine.
Indisputably, for upholding the democracy and the democratic values, holding of election is imperative. Paragraph 13, my lord, page 397. There cannot also be any doubt or dispute that keeping in view the constitutional mandate provided for clause provided under clauses 1 and 6 of Article 324 of the Constitution of India, the President of India or the governor of a state, that is the central government, as also the state government, have a duty to make available to the Election Commission or to a regional commissioner such staff as may be necessary for the discharge of functions conferred on the Election Commission by clause 1, in terms they are whereof a power of superintendence, direction and control of elections is to be vested in the Election Commission if requested in this regard is made. Article 327 of the Constitution of India empowers Parliament to make laws with respect to all matters relating to or in connection with elections to either House of Parliament or to either House of the Legislature of a state, including the preparation of the electoral rules, the delimitation of constituencies, and all other matters necessary for securing the due constitution of such house or houses. Parliament, with a view to give effect to the said constitutional functions enacted the Representation of the People's Act 1950 and the Representation of People's Act 1951. We may notice certain provisions of the said acts. So 50 and 51, these provisions have been reproduced here, or she may skip over. Page 399, 159 is also quoted at the middle. That after amendment, 97 amendment came thereafter. Then paragraph 20. We may however notice that prior to enactment of Act 12 of 1998, in terms of section 159 of the 1951 Act, the obligation to make available to any returning officer such staff as may be necessary in connection with an election was also confined to the local authority. 21. The question as to whether the staff of State Bank of India would be requisitioned for the purpose came up for consideration before this court in Election Commission of India versus SBI Staff Association, wherein this court upheld the judgment and order of the division bench of the Patna High Court, opinining that the officers of staff State Bank of India cannot be requisitioned in terms of section 26 of the 1951 Act or otherwise. That was appeal their challenge. The constitutionalized statutory scheme would lead to a realistic conclusion, 22. When emphasis was laid that it is for the central government and the state government alone to provide for the requisite staff. How would they do it in one thing? It may be by fresh recruitment for the purposes for which the staffs are requisitioned, or for deployment, or by way of deputation. Indisputably, there are certain functions which may be performed only by the government staff. For the said purposes, they may be sent on deputation. That is, section 21 and 22 of the 1951 Act provide for the returning officers and assistant returning officers who must be officers of the government or of a local authority. Therefore, their services can be requisitioned under clause 6 of Article 324 of the Constitution of India, as also section 159 of the 1951 Act. The Election Commission or the Regional Commissioner, as the case may be, is also entitled to request the requisitioning the services of the persons in the employment of the government or the local authority and others who may not be officers of the government or the local authority. The services of other employees who are not officers may also be requisitioned. Parliament was aware that in an election, requisition of services of the employees of the central government or the state government may prove to be insufficient, and thus a direction for appointment of the staff from amongst the officers of the local authority and others has been made. 23. On the other hand, however, right to education is held to be a fundamental right. It was so stated in Mohini Jain versus State of Karnataka in the following terms, quote, right to life is the compendious expression for all those rights which the court must enforce because they are basic to the dignified enjoyment of life. It extends to the full range of conduct which the individual is free to pursue. The right to education flows directly from right to life. The right to life under Article 21 and the dignity of an individual cannot be assured unless it is accompanied by the right to education. The state government is under an obligation to make endeavor to provide educational facilities to at all levels to its citizens. 24. The aforementioned ratio has been affirmed with certain modification by this court in Unikrishnan JP versus State of AP, expressly stating, quote, having regard to the fundamental significance of education to the life of an individual and the nation, and adopting the reasoning and logic adopted in the earlier decisions of this court referred to herein before, we hold, agreeing with the statement in Bandhua Mukti Morsa that right to education is implicit in and flows from the right to life guaranteed by Article 21. That the right to education has been treated as one of transcendental importance in the life of an individual has been recognized not only in this country, which since thousands of years, but all over the world. In Mohini Jain's, the importance of education has been duly and rightly stressed. The relevant observations have already been set out in para 7 herein before. In particular, we agree with the observation that without education being provided to the citizens in this country, the objectives set forth in the preamble to the Constitution cannot be achieved. The Constitution would fail. Then, my lord, Article 45 was referred to and discussed. Then please come to paragraph 27. Paragraph 27, in Brown and Board versus Board of Education, Earl Warren, CJ, speaking for the US Supreme Court, emphasized the right to education in the following terms. Quote, today, education is perhaps the most important function of state and local governments. It is required in the performance of our most basic public responsibilities, even service in the armed forces. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening this child to cultural values, in preparing him for later professional training, and in helping him to adjust normally to his environment. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. 28. The provisions of the 1950 and 1951 Acts, although were enacted in terms of Article 324 of the Constitution of India, the same must be given restricted meaning. It says, same must be given restricted meaning. Holding of an election is no doubt of paramount importance, but for the said purpose, the education of the children cannot be neglected. Therefore, it is necessary to maintain a balance between the two. 29. With an advent of technology, requisitioning of large number of people for carrying out the election may not be necessary. We may notice that the Election Commission has different roles to play. Preparation of electoral rules, revision of electoral rules, when objections are filed, hearing the parties and determining the objections, enumeration of the voters list, and to hold elections as and when due. The Election Commission and its officers, in our opinion, can formulate an effective scheme to see that the services of a large number of teachers are not required. Kindly note this. The state admittedly is not in a position to perform its sovereign functions of imparting education. Such functions necessarily are required to be performed by the private actors. Those students who are in a position to get admission in the public schools presumably would also be in a position to appoint tutors, whereas those students who are admitted to the government schools ordinarily would be from the middle or lower middle class or poor families. The state of primary education in India is in deplorable condition. There admittedly is heavy dropout from the schools, particularly from amongst the girls' schools. The question if right to exercise franchise, whereupon the emphasis is laid by Mr. Benugopal, is an important one. Right to education is also no less important, being a fundamental right.
Yes.
So, my lord, reading another two paragraphs. 30, the human rights conventions have imposed a duty on the contracting states to set up institutions of higher education, which would lead to the conclusion that the citizens thereof should be afforded an effective right of access to them. In a democratic society, a right to education is indispensable in the interpretation of right to development as a human right. Lawyer Sahidi has been referred to. Thus, right to development is also considered to be a basic human right. Then Lordship may kindly come to paragraph 33. We would, however, notice that the Election Commission before us also categorically stated that as far as possible, teachers should be put on electoral roll revision works on holidays, non-teaching days, and non-teaching hours, whereas non-teaching staff be put on duty anytime. We therefore direct that all teaching staff shall be put on the duties of roll revision and election works on holidays and non-teaching days. Teachers should not ordinarily be put on duty on teaching days and within teaching hours. Non-teaching staff, however, may be put on such duties on any day or at any time if permissible in law. So my responsible submission is, though it was in the context of a primary school, nonetheless, the importance of education, that too after the new education policy. New education policy, my lord, this has made it is more tough. It requires the 100% of the teachers to be given to the education institution. And there is advancement of their career is also dependent on that. Then the institutions are ranked in the national level. There's a ranking, NAAC, National Accreditation Council, they come and they assess. Because of these things, that time when the petition was filed, I do not have present status, it was downgraded. Because almost for every election, they were not taken for only 1 day, 2 days, for months together, 3 months of.
3 months?
3 months of. Because they were kept in what they have done, the authority has opened a group of in the WhatsApp. They don't release them. They simply send a message, come. You go there. This is how they perform. They were treated like so severely.
So now, you mean to say that the election authorities are taking work from them from months together?
Yes, kindly see, my lord.
So the Lok Sabha elections, the general elections are scheduled to be held in April or May. So nowadays they are engaged in this election duties.
Lordship, may kindly repeat it?
The general elections are expected to take place in April or May.
Yeah.
Now it's almost February half. We are already in the midst of the February. Whether these members of the association are engaged in election duties?
At the moment, no, not
Not
now.
now.
For now, not there.
Then
They have asked for some. না, এটা কিবা আমাক বিচাৰিছিল, কিবা database বিচাৰিছিল। এটা জেগাটো ফোন কৰি আছে। কেতিয়া? এতিয়া আছে কিবা? ফোন কৰিছে। এটা আছে, এইটো প্ৰথমটোতে আছে। প্ৰথমটোতে আছে। এইটো নহয় জানো? এইটো এনকাৰেজ কৰিব।
Yes.
Well, my latest instruction is that over telephone, they are inquiring about the individual cases. They are making individual cases are being called up over telephone, and they are asking their data to prepare for the list. Telephonic inquiries to individual cases from the district election office are being made to prepare for the election list. This is what the this is what the instruction.
General election is there, so they have to prepare in advance. And it's simply if they're asking something on phone, that doesn't mean that you are
If they do not do it,
stop
well and
from
good.
doing their teaching regular work.
Going by the nature, what they did, the past precedents, till the last election, 21. This time also they will repeat the same thing. That is what our apprehension is. We made representations to
For the
them.
purpose of conducting free and fair election, the election commission has to take every step, including engagement of the staff of various organizations, states, central, etc., etc.
Well, true. Therefore, we only want certain directions from this honorable report.
What?
That they should not go for say drafting beyond 30%. Beyond 30% of the total teaching staff.
That
If they are going for
Okay.
70%, then definitely it affects the institution. It affects the whole system.
Sir, it is.
There should be some guideline to that
The
extent.
requirement of the election commission or the concerned authority is to conduct the election, and for that purpose, what quantity of staff there in requirement of, how can this court can assess that
My lord-
only 30% would be sufficient?
My lord, I am just giving an idea. Lordships may consider it. But my responsible submission is, that's why while the matter came up on the earlier occasions, the division bench of this honorable court earlier directed the election commission to come up if they have any idea on this, whether they have promoted any scheme on this.
On which date such direction was issued?
That, as soon as possible. They took time to file affidavit, but nothing ultimately, affidavit delay, no, nothing has come. No, report is
Give a
already.
point of on which date the court has given certain direction.
My lord, just,
This is simply said on 28th of July. Assam State Election Commission prays for and granted 3 weeks time to complete its instructions.
that is regarding my lord panchayat election. How can they, that time the court's view was, how can they draft these university teachers for panchayat election? Therefore, what is their stand? They have to clarify. They were asked to submit that affidavit. What is the central government of Kuching, whether that has been categorically stated in the order set, but then that was the purport why they were granted several adjournments to enable them to file.
Waiting for the Election Commission of India. Have you filed your response?
Yes,
You already filed your response?
yes.
Election commission
Election commission. They have, but,
has not filed.
they are-
Election
they have been
commission,
completed.
election commission had decided, I'm sorry, election commission has filed it, not the state election commission, they have not filed.
What affidavit filed on your honor 15/6/21.
Way back. You please, now take your.
Yes, sir.
On 28/9/22 also, this was adjourned to enable them to file affidavit. Deputy Solicitor General of India adjourned to 19/11/2022. It was on 28/9/2022, my lord. And thereafter again,
আৰু ক'ত আছিলে? কাৰ হৈছে? LDB কাৰ হৈছে? সেইটোৱে। Request was made on his behalf again on 17/1/2023.
Anybody is appearing on behalf of state commission? Would you like to file any reply? So basically, you are following the directions or guidelines, whatever given by the election commission. Yeah, how can they have any independent view in this matter?
That is why now whether after all this, having found that there is still grievances, certain the authorities there under the commission has done in a way which has affected the institution. What is their take on it?
If you have some grievances, you can represent them. And at the most, we can direct them to consider those grievances objectively and to make endeavor to redress those grievances. But so far as regarding validity part of this section 149 is concerned,
159.
well, 159 is concerned, we are not, we don't find money.
My respectful submission, having gone through all that, I would like to press on, I would not like to press on it hard. I leave it to your lordship, but then my grievance basically is this indiscriminate way of doing things, which has affected not
That
the whole
For
institution.
that purpose, what we propose that you move a representation when it is for.
No, that was done. I have annexed it. Long time. That was done. Kindly see, let me place their own guidelines they have formulated after that SBI case. After that case of the Bihar, the Bombay case, after that Bombay case, I have placed it. Kindly see those also.
117. This is the handbook.
In their handbook of handbook for returning officers.
Critical mass. 50 चाहिए तो 50 लेगा, 150 चाहिए तो 150, किसी की बात नहीं, उनका समय वो मतलब मैं ये है कि ठीक है आप अपना डिविडेंड पे देते हैं, they consider public to be very genuine, the police scheme payments में आप बोलते रहते हैं, ये सब उनको जो चाहिए बोले, ये कोई भी
This guideline is issued when?
ये जो SBI का कई SBI they have amended this 159.
Kindly come to page 117. They have issued a notification to that extent, Election Commission. This was of 16 February 2010. It says it was addressed to the Chief Electoral Officers by the Election Commission. I am directed to invite your attention to Commissioner's letter number such and such dated 30/12/09, whereby the Commission has directed the Chief Electoral Officers of all states, union territories to adhere strictly in true spirit to the guidelines while making appointments and requisitioning staff for the conduct of free and fair poll. At page 117, my lord. It says in a second paragraph. In this connection, the commission further desires that Group A or equivalent senior officers, including teaching staff of universities, colleges, etc., should not be drafted for polling duties in polling station premises without specific reasons to be recorded in writing. by the district election officer, where such appointments become unavoidable. Well, Lord, here is no,
So once the election commission involves the teachers, if somebody is having any problem, any difficulty, there is a mechanism to address that.
individual case,
Correct.
individual case, my lord.
Individual
One-
case, correct.
But here, as Lordship has seen, election duty important, very urgent, you are to come. Even when they have applied for that I have this difficulty, that difficulty, authority says nothing. My lord, I have not disclosed everything, but they are treated so civilly there that a clerk deals with them. They are called, immediately come university teachers, there are doctorates almost all, come, go for this work, go for
No,
that.
that-
This is how
that's
they
all
are
right.
treated. This is another aspect.
Mr.
I'm not
Mahanta,
coming
the
on.
question is, there has to be a practical approach.
Yes,
Correct.
yes.
This election, general elections in a country like India is a very gigantic exercise. When the ball starts rolling, what would be the magnitude, what would be the demand, what would be the challenge? Nobody can visualize that. And once the process starts, it is the Election Commission of India which is solely responsible for conducting the election. So today inside this courtroom, can we decide that it should be 30%?
No, Mala, that is what I'm saying.
32.5%.
That is, I am giving at least, there should be some limit. What will be reasonable?
That's
limit?
right.
If they decide,
If the situation demands 100% or 150%,
that has to
that
be.
will be done.
Mala, that
How
is
can
why,
somebody stop it?
that is why, Mala, true. Something is difficult to visualize by being within the four corners of this courtroom. But at the same time, it is not difficult to visualize the situation. If 70 to 80% staff of a particular institution, university is drafted, then what would be the plight of that institution? That we can also realize.
But if for shortage of manpower, the election process gets scuttles,
Malad,
who will take the
Malad,
responsibility?
my response submission is a huge exercise by a huge state. There are so many officers. Government officers. There are many. Why they target the university alone?
Tomorrow, this association of the civil servants, IAS officers will come and they may say, okay, sir, we are posted as observers for months together in different states and different region. That would detriment to their rights or whatever it may be. Can we say that those persons can be appointed as the observers or also?
Malad, my
It will open a Pandora box if we interfere in such matter.
that apprehension
Every
is there.
set of employee, every set of the persons who are engaged in election duties may come before this court and say, I will not do this.
Malad, I will request your lordships to confine to the petitioners who are before your lordships. May not consider the other officers because they have not come with a grievance. Therefore,
So far
an
as
administrative
regarding this
officer and
virus of section 159 is concerned.
Yes.
That has already been upheld, I think, no?
Malad,
That by one
As-
of the high courts,
Malad,
but most probably in Rajasthan High Court, that has already been upheld.
Lordship,
it is interesting.
Rajasthan High Court already decided the issue.
No, it is Rajasthan High Court.
Honorable
Lordship
Rajasthan High
High
Court
Court.
as well as Patna High Court also decided
Patna
that.
High Court has also said laying down certain guidelines. They didn't go to the aspect of virus, but laid down certain guidelines. And your lordships, High Court, Rajasthan High Court has.
Lordship's High Court is Guwahati High Court now, Mr. Mahanta.
Presently, no, earlier High Court, I stand corrected because the lordships earlier High Court.
I have placed on record judgment by the
Seems you have not here accepted me till date.
No, no,
Seems.
we have already accepted, but to remind that part, I had to refer to that.
I forgot that.
Oh, yes, Malad, I am grateful, Malad.
Lordship, I have
I
committed
agree.
judgment passed by a single bench of the honorable court.
Your lordship goes to the name of the petitioner, your lordship. Lordship, I'll just point out petition number
Just a
7.
minute, let me
is
finish.
it the-
Let me finish. Malad, lordship, that Bombay High Court committee, sir, how could you say? Magad University. In a Bombay High Court decision, lordship has got this copy, Malad. my lord, this Bombay High Court decision, is it before your lordship, my lord? 2009, 6 AR.
Yes.
Yeah, kindly see, the Bombay High Court has ultimately para 27. Paragraph 27, lordship may see.
Therefore, since we found that after the amendment in section, power to requisition of agency, we consider what manner power should be exercised. Yes, what are we referring to?
Therefore, my lord, the court has expressed its mind that at the minimum, and the election commission has also said in its own notification that at page 117. 7 of my writ petition.
What they say?
After this judgment,
18 February 2011.
18 February 2011, they have issued this notification. 16 February 2009.
18 February 2011, Annexure 22, page number 119.
18 February 2022. This notification was issued by the Election Commission to the Chief Electoral Officers, requisitioning of staff of election purpose regarding. This is the subject.
Yes.
At
Para 6.
at paragraph 4, they have referred to these provisions of law, High Court's decision.
117 you are referring to?
No.
119.
Now presently go for 119, madam. I will come to 117 later.
Yes.
Yes, 119, this was after the decision of the Bombay High Court, they issued this. Requisition regarding notification regarding requisition of staff for election purpose. This was issued. 159 they have referred to, first para. Then third para 26 representatives of people, say 51 referred to power to appoint. Third para, they have referred to all these acts and the High Court decision. The High Court has also made an paragraph 4, my lord, towards the last fifth line. The High Court has also made an observation that while requisitioning staff, all the organizations should be considered so that some institutions are not picked up selectively, ignoring the fact that deployment of large number of staff from a few institutions would be likely to result in hardships in the business of such institutions. That has been categorically said. Then fifth paragraph, High Court has been referred to a copy of the common order so and so. Then guidelines, paragraph 7, lordship may kindly come to. The following guidelines should be kept in mind. Based on the availability of staff in the institution covered under section 159(2) and the requirement of staff, the staff may be requisitioned from such institutions. The commission has exempted certain officers, institutions for the purposes of election duty in view of the essential nature of duties, services discharged by the institution. This should be kept in mind. They have said this. C. Employees of the bank, LIC may be drafted on election duty to the minimum extent possible only in a constituency where sufficient number of government employees are not available or in emergent circumstances such as strike, etc. by the government employees. Care should be taken to ensure that normal functioning of banks, LIC are not interrupted. Care should further be taken to ensure that minimum number of employees of such institutions is requisitioned so that the business of these institutions is not hampered. It is reiterated that, paragraph 8, while requisitioning of the staff of the conduct of future elections, their rank, salary, etc. should be kept in mind while making appointment and assigning duties to them. This instruction earlier so and so 13 December 90 shall be treated as superseded by the instructions notified later. So 2009 instructions have been taken back and this was issued.
Mr. Ali,
Yes, Lordship.
after this 2011 instruction, any further instruction has come now?
Yes, Lordship. As regards, I have given a copy of the polling handbook of returning officer, Your Honor. I have given a chapter of the polling personnel,
Handbook of polling officer.
returning officer, handbook for returning officer, that the chapter polling personnel, Your Honor. I have given the compilation, Your Honor.
Polling person, yeah.
Your Honor. The Honor comes to 3.2. Based on-
Yes.
3.2, Your Honor, to
General
the general guidelines. If Your Honor comes to, these are the guidelines that have been set in, Your Honor, after various judgments, Your Honor, and in fact, number D, that is seniority of officials should be properly taken care of while giving elections related duty, as it should be ensured that a senior official is not put on duty under an official who is quite junior to him or her. Presiding officer and polling officer are to be classified on the basis of scale of pay and their post and rank in determining the rank and status of official drawn from different pools with different pay scales. The relative position of the officials in his cadre organization may be taken into account and not merely the pay scale. Say, for example, a Group D employee from any pool, even if drawing a higher scale, should not be assigned duties of a presiding officer or polling officer. The presiding officer should be of higher scale or grade in comparison to all polling officers. Lordship, this is one of the grievances of the petitioner in this writ petition. If your Lordship comes to page 12 in para 10, this is one of their grievances where they said that they have been made to work under officers who are drawing lesser salary than or in lesser gradation to them. Your Honor. So in fact, election commission has taken care of this vacancy, Your Honor, and a writ petition was filed by the petitioners in individual capacity, Your Honor. I have submitted a copy, Your Honor, WPC 1955 of 2014. Yes. Your Honor, if Your Honor comes to this, if Your Honor will see the list of these are total 62 petitioners, and all of them are professors of Assam University. And in fact, petitioner number 22 is the president in charge of Assam University Teacher Association, Your Honor. And president number 17 is general secretary of Assam University Teacher Association. And this writ petition was filed in the year 2014 while they were drafted for election duties in the year 2014, Your Honor. And this the instant writ petition was filed in the year 2021 February. However, Your Honor, this writ petition 1955-2014 was disposed of on 38-2022 during the pendency of the instant writ petition, Your Honor. And while passing this honor, this judgment, I will just read paragraph 3, Your Honor.
Yes.
The grievance of the petitioners are that they have no objection to offer their services under the Election Commission of India for the purpose of smooth conducting of election. But while allotting their duties, they should not be allowed to work under any officials who otherwise in the hierarchy of rank in respect of the service where the petitioners are engaged to be below that of the petitioners or otherwise junior to them. According to the petitioners, such requirement while performing the duties under the Election Commission of India violates their legal rights and also make them to work under a person under whom otherwise they would not be required to work. Mr. A. Learned Counsel for the Responding Election Commission of India has made a statement upon instruction that the Election Commission of India has taken note of the aforesaid grievances of the petitioner. And in fact, in the subsequent election, the officials like that of the petitioners were allotted different duties under the election commissioners, namely micro observers, additional micro observers, assembly level master trainers, etc. As the respondents in the Election Commission of India had taken note of the grievances of the petitioners, were of the view that no further adjudication is required. Accordingly, this writ petition is closed by providing that the respondents in the Election Commission of India shall take note of the rank and seniority of the petitioners even in future if they are required to serve for the purpose of election duties under the Election Commission of India. So, this writ petition was disposed during the pendency of this instant writ petition. And in this petition, they have admitted that they have no objection while to perform the election duties, Your Honor. It's provided the seniority is
That was
kept
in
on-
the year 2022, now they
22.
have objection.
Yes.
When you restrain them from raising
Yes.
any objection.
So, my humble submission is here. And my humble submission, Your Honor. In the last election, 2021, quite a large number of persons has to be drafted during election because it was conducted during the time of COVID pandemic, Your Honor. And a huge number of reserve staff had to be organized by the Election Commission because suppose a person was detected COVID positive, again, the home quarantine, all these things comes up, Your Honor. However, that was not the issue in other elections and even in this election, Your Honor. So that has to be kept in mind, Your Honor, because it is because of that a larger number of persons were drafted from the petitioner association.
This, these are the instructions which were,
This is, Your Honor.
these instructions were issued when,
These were 2019 guideline, Your Honor.
2019.
19, this compilation.
Where is the handbook?
This is the- For 2023 also latest handbook has
You are-
been released. Your Honor.
You are going to issue a latest handbooking for the ensuing
It
election.
has already been issued. If my submission, I can provide it to the court.
Where is the latest one?
Latest one, I have the soft copy. I don't have this hard copy on.
Okay,
It's a, yeah, I.
send it. Similar provision is there in that.
There's similar provision. I'll just.
My lord, as I referred to page 117 of my writ petition, their own notification, that should also form part of the guidelines. In that case, they are to follow it, but they are not following.
There-
This was done way back
that
in
is-
2010.
That is their circular, and they are supposed to follow it. They have issued that, they themselves have issued that circular.
They are not enforcing it. They are not following it. Officers here are not
It's a
following it.
complete compliance.
Page 117,
Similar to
lordship will see very categorical.
Then that may be, that may give you a,
But the question is, my lord,
rise to give a challenge to it before the appropriate forum and not while challenging
my
the
lord,
validity of the
my
provision
lord,
itself, sir.
my lord, my response submission, yes. I do not dispute on that, my lord. But the question is, when despite all these, authority is behaving in a manner which is prejudicial to the entire system, then what is the remedy? This honorable court can only say, and in my response submission is the appropriate forum to direct them that you either go like this and consider these aspects and formulate your guidelines. And
They have already, in the handbook, they have made appropriate provision for that, sir.
in their notification, they have said that Group A or equivalent senior officers, including teaching staff of universities, colleges, should not be drafted for polling duties in polling station premises without specific reasons. If at all required, they should write the reasons. Nothing has come.
In paragraph.
These are all on paper.
Appearance to learn. Appearance to learn.
'21, my learned friend says COVID was there. COVID was for us also.
Sir, individual capacity, when you filed this petition, you simply raised an grievance regarding that and with a categorical statement that we have no, what your statement was that we are not opposing the action of the election commission of assigning duty. The grievance of they have no objection to offer their service under election commissioner for the purpose of a smooth conducting of election.
Well,
This was your categorical statement in the year 2022.
my lord, I'm sorry, that would have gone from my side. That order ought to have been placed from my side. I'm sorry. My learned friend has placed it. It has come to my knowledge. But then that was an individual petition by some of them.
Individual.
And
petition,
here also, we are not
they-
saying
Individual persons, as many as, how many persons are there?
62 years.
62 professors or lecturers or whatever it may be, they approach in individual capacity where they say that we have no objection.
no, but here also we are not
And here
opposing.
as an association, now you are objecting, that don't assign us
No,
any
my
election
lord,
duties. sir.
In fact, we have here in categorical terms have not said that we are not going to perform duties. But there should be a reasonableness. Only thing is that you cannot in that scale take affecting the whole institution.
What is reasonable in your view may be unreasonable in the party which has to conduct the election.
My lord, that is
They
why
are the best judge for how many persons are required, what type of duties they have to assign. How this court can.
well,
analyze
that
all
is
these
why
things?
that is why I referred to their own notifications where they have said that you must record the reasons if necessary.
Whether they have a single word they have uttered, together, no, despite this notifications, we are not going to abide by those.
No, but they have not, practically they have not followed. Practically they have not followed. Why so much of people? Now they said you send us the database, university. And one after another, all are recruited. And they should have given reasons that we need this much because of this reason. Nothing. Can they show that these orders were issued in that form? Did they apply ever their mind? No. Because this is a soft target, my lord, is a pool of officers in one go, in one group. They are immediately found there. They are all resident in the university campus. All these officers are there. In one group, they are found and they are taken at a lot. That is one reason to my understanding, to their understanding. That is a soft target. And college teachers, what we appreciate, college, university teachers, they will.
Almost every department and number of officers are requisitioned for that purpose. Not only the university officials, that this university professors or lecturers are being requisitioned for that purpose.
True,
That is
true.
not-
But the practical, physical ground reality is such that in all other officers, the officers do not reside in one campus. They are the officers, they reside in one campus, and giving the letter to the registrar, they can serve.
That is not.
This is how they-
difficult, Sir, even though if if the officers are residing at distant places, that is not difficult for the government, mighty government.
Catch them.
To instruct them to come at one
Well,
go on a one date, though they
yes.
are residing in
My lord,
separate places.
we are not denying that. We are not denying, but what we are saying is, probably this is the reason they find us in one lot, in one place.
So it's not that the government has to locate every person where he is there, where he is staying or where he is residing, and then only they can call. They have to issue a letter in the name of the person and he has to report that.
Probably here, the way things have been deliberated versus fallen from your lordship, those were not the considerations prevailing in the
So
mind.
the members of the association has created a wrong perception that we are the soft targets because since we are living in a one campus, therefore we are the soft target.
But that is what
Can't
the
be.
impression we have got, because every time that happens by writing a letter to registrar that we need this much, these officers, you made it.
To whom they write? They'll write only to the registrar.
True,
The registrar of the university is the chief executive.
true, my lord. No, we are not saying that.
Registrar only we are in requirement of so and so staff, so please.
Therefore, the registrar do have raised objections, the vice chancellor do have made representations. Nothing has yielded any result that this much, we cannot. I have annexed those annexes also here. I have annexed those annexes. এখন কিহত দিছা? কেতিয়া এইটো? কিমান টাইম দিছে?
These 65 petitioners later on are have
Are
found
members of the association. These 62.
Should be, should be.
They are members of the association.
Yes, should be, my lord. I think they are, because this is the association who represents the teachers. So they are also teachers. They should also be members.
Once in view of this order, sir, how can we admit this petition?
My lord, this is on that, but as has been found, as written there. This was filed in 2014, decided in 2023.
So the statement is given in the 28-2 only.
True, my lord.
2 years have also not passed. 30th of August,
My
2022.
lord.
The day, the grievance of the petitioner, they have no objection to offer their services. And even though in 2014 we have no objection. Then why in 2024 you have objection?
No, my lord, as a democratic person, the democratic process probably we cannot deny totally. Therefore, my respectful submission here also, it is not the case we are totally against it. It is not, but we only want that it should be sus.
Mr. Consul, then we suggest you give up your challenge to this. And even though this is not maintainable, in view of the fact that various high courts have upheld the validity of this section 159, and we don't find any different reason to take another view. And so far as regarding your grievances are concerned, you may file a detailed representation and will observe that the election commission may consider the same in accordance with law and in accordance with the guidelines or the circulars issued by it from the time to time. It can only be done.
My lord, then in that case, I will pray only for a time frame so that they act because it is offering.
Expeditiously, we'll observe expeditiously. Time frame, but it's
That will otherwise, my lord, we apprehend a similar kind of treatment in the next election also.
whatever the representation may be decided in expeditiously.
Yes, I'll make sure.
Will record his assurance that will be considered and addressed expeditiously.
Losses may otherwise, I am just expressing my mind, since the other high courts have also laid down certain guidelines. In similar terms, lordship may add something more if your lordships like it.
Something more.
That it will be binding directly on our
When
officers
other high
here.
courts have laid down certain guidelines and the election commission is following it. And that would serve your purpose.
The lordship may
Which
kindly,
is that judgment, they upheld constitutional validity as it been upheld.
Rajasthan High Court. Rajasthan High Court.
into Rajasthan High Court. The Balwan is good, दिया नहीं जाए, दिया नहीं?
Chalendra Singh Balwa, Your Honor, relevant paragraph is 8, 10, and 11.
Yeah.
8, paragraph number 8, 10, and 11.
Yeah.
11, last 5 line, Your Honor, if I may read. The above observation of ours, in fact, answers the challenge to Vyers 2. It is well settled that Vyers of a provision can be challenged only on the ground of legislative incompetence or violation of fundamental rights. No case of legislative incompetence has been made out, and in the absence of breach of any right, much less fundamental right of the petitioner, we do not think any challenge of Vyers can be entertained at all. The entire case of the petitioner is founded on Article 324 Clause 6 of the Constitution and the decision in Election Commission versus SBI Staff Association Supra, which we have dealt with earlier. We do not find any conflict between Article 324 Clause 6 and Section 159 of the Act. In our opinion, the petition is totally misconceived. I'm also relying on the judgment on this or the Patna High Court. Yes. I submitted Magadh University Postgraduate Teacher Association and others versus the Bihar State Election Commission and others. I have submitted a copy of it.
Magadh University Postgraduate.
Yes, and Magadh University Postgraduate Teacher Association and others versus the Bihar State Election Commission and others.
Yes.
Relevant, I will not draw the entire paragraph. If the relevant paragraph 10, if your honor comes to last page. Last second page.
Supreme Court.
Yes, sir. On the Honorable Supreme Court also considered and distinguished earlier decision in the State Bank of India officers case, Supra, and held that in view of the amendment, earlier decision is not applicable, as can be seen from the paragraph 26 of the judgment. In any event, since the university officers are not teaching children up to the age of 14 years, Article 21A of the Constitution, as well as arguments based on decisions of the Supreme Court, is not applicable in this case. 11. It was also contended that staffs means only teaching, non-teaching.
Yes.
We are unable to agree that staffs means only non-teaching staff. Staff mean teaching staffs and non-teaching staff. In case of section 159, subsection 2, clause 2, teachers can also be summoned on holidays. In St. Mary's case, Honorable Supreme Court also held that besides teaching, they can also be deputed on holidays in view of Article 21A.
Yes.
So we have. And on our polling day is always a holiday on a declared. Only
Only also relating to this university teachers only.
Yes, sir. And whenever they engage this presiding officers on the polling day, their duty is required on. Only one day, sometimes they are required for a training on. So basically 1, 2 or 3 days, maximum their duties are required here.
Yes.
My lord, that decision, Patna High Court, while negating the challenge of constitutionality of the particular section, the court has ultimately observed, last paragraph, Lordship will see, 12, last part.
Magad High Court that, Patna High Court judgment.
Patna High Court, that Magadha University,
Yes,
last few lines of the paragraph 12.
yes.
The Honorable Supreme Court in St. Mary's case, what has been referred, then said, we are of the opinion that as far as possible, teachers in the schools and universities should be avoided for election duty, and they shall be posted only in exceptional circumstances. That was the observation made.
Where is that?
Lord, paragraph
St.
12,
Mary's case, we are of the opinion that as far as the school union should be avoided election between they shall be posted action. The union shall make appropriate direction in future election, but since no alternate arrangement cannot be made. Based on
that was at the eve of
Just
election.
a suggestion.
Yes,
It's
observation
just a
made.
suggestion from the court and no mandate.
No, my lord, that was the observation
Suggestion from
given.
the court, they should not be, but it's not a mandate that
Following-
can't be.
No, no, well, following the direction of the apex court in St. Mary's case that was placed, this court has said. Yes, put question in, please. And
Just to feel the concept, how to show that I'm very progressive. Yes.
Lord, regarding the numbers and the period, the registrar's letter, which is filed in my rejoinder affidavit. Lordship may kindly see.
We are not satisfied if we dispose of this petition that you are giving up the challenge to the validity of section 159, and we are granting you an opportunity to move appropriate representation. And we expect that the election commission or the respondent shall take into consideration the said representation regarding your grievances objectively, and will take a decision in accordance with the circulars issued by it from time to time.
Including the guidelines laid in the hand.
including the guidelines laid in the headbook. If you are satisfied, it's okay. Otherwise, then we have to pass a order on that. And
Not that-
after taking note of this fact that earlier also you approached in the individual capacity where you have said, "Okay, we have no objection," and now you are objecting to it.
No, my lord.
Then we have to make certain observations in
My lord.
of your conduct also, sir.
No, my lord, as I am placing repeatedly, we are not opposed to it that way. But the way, kindly see, the registrar has said in one last election, they were
Yes.
last election, I will just refer to that annexure of my rejoinder affidavit, registrar's letter. It says, total number of teachers drafted, this is a registrar's letter, my lord. Total number of teachers drafted for election counting duty from 3rd February 2021 to 2nd May 2021. 181 total. 181. Capacity of teachers in the main campus was approximately 300. 181 was taken from 3rd February to 2nd May, up to 2nd May. February, March, April, May. Huge number of teachers have been redrafted for additional duties. Total number of teachers were released from election counting duty on 11/5/2021 was 16. On 11/5/2021, only 16 was released from duty. Otherwise, all they were kept in duty. That is how they are treating. That is how, my lord, the things have gone to that extent.
That's why only we are giving you a liberty to raise.
I leave it to your lordship, my lord. Only thing is that to ameliorate the grievances, to look into it objectively, lordship has said, and to take the call within a time frame, my lord.
Okay. This petition is filed by the petitioners. Petitioner Association. Challenging the validity of the provision of section 159 of the Representation of People Act 1951. Stop. Reply to the writ petition is filed on behalf of the respective respondents opposing the submissions made on behalf of the petitioner association in this writ petition. Stop. After attempting to argue the matter on merits for quite some for a long time, learned counsel for the petitioner has submitted that he does not want to press this petition questioning the validity of section 159 of the RP Act 1951. However, seeks liberty for the petitioner association to move representation before the concerned officer of the Election Commission of India, oblique State Commission for State Commission for the State of Assam, Commission of Election,
State Election Commission.
State Election Commission, Assam, for redressal of grievances of the members of the petitioner
Regarding assignment of election.
for redressal of grievances of the members of the petitioner association regarding assignment to them, regarding assignment of election duties to them. Full stop. The counsel appearing for the respondents have no objection if the liberty prayed for is granted to the association, petitioner association. Stop. In such circumstances, this writ petition is disposed of as withdrawn with liberty to the petitioner association to move appropriate representation before the concerned officer of the Election Commission of India oblique State Commission of Assam for redressal of their grievances regarding assignment of duties, election duties. Full stop. If any such representation is filed by the petitioner association.
As expeditiously as possible.
Within a period of 1 month from today, it is expected that the authorities, the competent authority of the Election Commission of India / State Election Commission of Assam shall consider the same objectively in the light of the guidelines issued by the Election Commission of India from time to time and the provisions of the handbook for handbook for returning officers
Issued by the election.
issued by the Election Commission of India. Stop. Expeditiously.
Sir, within a period of 2 months, my lord.
Certainly before the election, they has to consider and decide this.
There is, my lord, at least
Expeditious.
just before the entering election, they should take a call. So that it remains effective.
Because the election may
Expeditiously
be.
means expeditious.
Leadership. The time frame.
Instruct your officers. to do
Yes,
this.
Lord, I'll.
Lordship may record that statement that they are agreeable to do it.
Yes.
Okay,
We'll
we'll-
direction they are not.
We'll make.
We'll do.
Yes,
We'll do.
my lord,
We'll-
this will help us.
Court's direction, Your Honor, we'll
We'll
comply.
make observations. sir.
Oblige, deeply oblige.
Sure.
Item 50, fixed at 2.
Yes,
Need please allow, sir. Today we have filed our affidavit, Mlad. Only
have
Mlad, I'm praying for a leniency, Mlad, as regard time period. Mlad, your lordship kindly see, Mlad.
how much time you want?
But what has happened is, Mlad, mine is a running factory, Mlad. There are 1
Time,
month,
time.
25 days to 30 days, Mlad, we could complete. Mlad, because we have to construct one wall, then demolish it.
In a period of 1 month,
Yes, yes, Mlad.
you'll do it.
Yes, yes,
Where is
that,
your affidavit?
Mlad, we have filed today. It's there. Page 89 starts. Para 5 months.
Remove the enforcement. Make their own. They have to run quantity targets.
Yes,
Don't have.
but what they are apprehending, that tomorrow again you will come, no, that
Yes,
measurement
yes.
was not correct and now you have to.
Paragraph 4, my lord. They are suspecting paragraph 4. My lord, here only subject to strict compliance of the measurement made that carried out on 30/11/2000, we definitely will not do. Because we have already put pillar there. Because either during, we have to be.
In future, you may not come and say again, no, that was that measurement was not appropriate, that.
No, will not come.
December.
Because my officer was there that day. That is it.
Maybe, but sure this, will record your statement. Of this effect, will record your statement, yes, the authorities, NHA authorities will not, would not, would accept the said measurement and would not raise any further claim against them in future.
Yes. So, this one, may I prefer like adding one line for my safety, because as my officer was present, that NSA officer was present.
Yes.
Your
officer was present.
your safety is in your hands.
My lord, here because so big department on the spot I cannot, because as my officer was present that day, my lord. That is why it is to be recorded as my officer was present, NSA officer, site engineer is present, that is to be recorded at least.
Okay, this intra-court appeal is filed by the petitioner being agreed with the petitioner's appellants being agreed with the other.
16/11/2000.
16/11/2023 passed by the learned single judge, while whereby the writ petition filed by the petitioners has been dismissed.
But it was not dismissed, Lord, the direction was issued. Carried out a first, again, Lord, the measurements.
But disposed of.
Yes, yes.
Disposed of.
Para 14 direction, Mali, at
Yes.
page 87.
Hence, has disposed of the petition. The direction to the respondent authorities to conduct demarcation of the land in question on to conduct demarcation proceedings of the land in question on 30th of November 2023. The appellants were granted liberty to participate in the said demarcation proceedings. And the court has further issued a direction that while carrying out the said, and the learned single judge has further issued a direction that while carrying out the said demarcation proceedings, the respondent authority shall take into account the maps prepared during the said acquisition, during the acquisition proceedings, and has also made it clear that if the petitioners participate in the said demarcation proceedings, a copy of the demarcation report shall be furnished to them immediately upon the report being prepared. Pursuant to the direction given by this court, demarcation proceedings were carried out on 30th of November 2023 in the presence of the representatives of the, or in the presence of appellant number.
But appellant number 2 son was there, Lord. He's an
The
authorized.
representative of the appellants, wherein it was found that the petitioner has encroached 2.5 meters of NHAI acquired land in the southern side and 4.8 meters of NHAI acquired land in the northern side. Bracket में कहते हैं ना 45.6 meters in length, both side bracket rows, and the boundary wall of the petitioner is situated over NHAI acquired land. Appellant कहते हैं इसको, यहाँ पे petitioner है ना, substituted with appellant. Full stop. The appellants have assailed the order passed by, the impugned order passed by the learned single judge on various grounds, however. During the arguments on, during the course of arguments took place on 12/2/2024. When this court was not inclined to grant any relief to the appellants, learned counsel placed some time to complete his instructions. Stop. Pursuant to that, learned counsel for the appellant has submitted an affidavit sworn in by the appellant number 2 on behalf of the
Appellant number 3, my lord,
appellant number 3
on behalf of all the
on
appellants.
behalf of himself and the appellants.
Yes.
That the appellants are ready to remove the encroachment as per the measurement proceedings dated 30th/11/2023. However, praise reasonable time to do the same. Full stop. The para number 4 and 5 of the affidavit submitted on behalf of the appellants reads as under. Learned counsel appearing for the respondents has no objection if reasonable time is granted to the appellants to remove their possession over the disputed land, to vacate their possession over the disputed land. Full stop. Learned counsel for the NHAI has also submitted that the measurement dated 30th/11/2023 is acceptable to the NHAI authorities, and they would not raise any further claim against the appellants in future. Full stop. In view of the undertaking given by the, in view of the affidavit filed on behalf of the appellants and the undertaking, and the statement given by the learned counsel for the NHAI, we deem it appropriate to dispose of this appeal with a direction to the appellants to remove their possession over the land of the NHAI as indicated in the measurement proceedings dated 30th/11/2023. Within a period of 4 weeks from today, it is made clear that the possession over the land of the NHAI shall be removed positively by 18th of March 2024. In any case, the possession of so shall be removed on 18th of March 2024.
Lodge.
Item 53,
I'm extremely sorry. I'll just take 15 to 20 minutes. Well, your lordship may come to the paper book, page 117.
117.
117, my lord.
My lord, can we take little liberty, my lord? I think this matter is likely to take some time. Next item, there is one item, can we have after 54?
That was urgent because your lordship has granted permission also.
Any date?
54.
Yes, what do you want?
So my lord, this matter, if it is not inconvenient, can be taken up on 29th? 29th is a Thursday. 29th. There is an affidavit in reply has been filed. We received the copy. Maybe if advised by the client, we may be allowed to file a rejoinder.
At the request of the concept of the party, this matter, this item number. This matter for hearing, 29th of February 2000. Yes, 29th is okay.
My lord, if your lordship, can it have it on 22 or 23? My lord?
In fact, Lordship,
22nd.
Lordship, in this matter, the petitioner have filed a affidavit. So we have gone through that affidavit. In fact, we need to file a rejoinder.
The affidavit कितना देर लगेगा? Hardly
In the meantime, we will file.
response. File your
We will file a rejoinder.
26th or 22nd of February 2024. In the meantime, parties may complete their petitions.
And the interim order will continue till the next day.
Interim order, if any, to continue till.
Deeply alright.
Deeply.
Oh, Commander. 48.
You take all the time. I have 10 minutes, he's taking all the time.
Sir?
I have 10, 15 minutes, I want to complete it. I started.
Okay, well, okay, whatever date you want. Okay, fine.
Your lordship has fixed the tender method today, but I don't think that will also reach. My lord, your lordship will fix a comment. Tender date in Mr. Chaudhary appears on the other side. I have taken that. As per convenience.
For what?
Oh,
We have
hearing.
already closed for orders.
Hearing.
It is for hearing.
It's a hearing, public road.
Item 59.
59.
Which of that, yeah. 51 and 53.
Yes.
59.
59. We'll pass over for the day.
Your lordship will fix a.
Whatever want you, who is for the other side in that matter?
I've informed Mr. Chaudhary that he has asked me.
Which date?
22nd.
22nd, we have listed just now,
Oh.
this case also.
29. 27th Tuesday. My lord, subject to your lawsuits conduct. 27?
27, no problem.
Yes, Tuesday. We are obliged, madam. Sorry.
1 minute, Mr.
Mr. Consul, we can do one thing.
Yes,
We'll admit this appeal, the 51.
Yes.
And list it along with the
other.
Yes,
the parties are the same.
Yes, same.
Parties are, I have given copies to.
And he has furnished us the copies.
51 Medicare. Admit parties are represented to the council. Hence, no need to issue notices to the parties. It is noticed that against the impugned judgment, another appeal, writ appeal number 36/2024 is fixed for hearing. List this appeal along with writ appeal number 34/2000. Sorry, number uska, it's different na?
36/2000.
36/2000. On 27th.
28, my lord, my assisting counsel has some
28th,
personal difficulties.
28th of
Deep level.
February 2024.
Thank you.
Yes. Here is Vishnu, but we have to do something. Yes, yes, Mr. Counsel.
My lord, the page 117,
117.
towards the middle, my lord. It's an admitted position.
Yes,
It's an admitted position that Hailakandi B.Ed College, which has been renamed as Dr. Sasi Bhushan Institute of Education, was established on 31/12/1995. This much. There is a clear admission that they established themselves on 31/12/1995. That is after
17/1990.
17/19. Now, well, there is a decision that was placed by other side. That is Dr. Bhupendra Nath Tripathi. Dr. Bhupendra Nath Tripathi Your Lordship has the copy. 1013 there.
It's a compilation page 22.
No, I don't have access to, but
Compilation.
my lord, your lordship will come to paragraph 2. The facts of what was the issue in the case? Page 206, paragraph 2.
Yes,
Uh,
paragraph 2.
Paragraph 2, what was the issue? Just 3 lines below the placetum F. Placetum F is on the right side, just 2 lines. The High Court held, my lord got it.
Yes,
The High Court held that exclusion of candidate from the field of eligibility of the said course who have obtained degree prior to enforcement of National Council for Teacher Education 1993 or after enforcement of the Act during the period when the application of any institution or university was pending consideration. So, your lordship remembers section 14, proviso to subsection.
Mr. Mishra, you are reading from which judgment, which para?
My lord, the state of UP versus Bhupender Nath Tripathi, 2010-13 SCC,
Para
page-
number? Para number?
paragraph 2.
the state of Uttar Pradesh is, and its authority are in appeal before us challenging the correctness and judgment of the rendered by a.
Yes, yes. That it's a relevant portion only because of the paucity of time
The
and
High
place.
Court of the restricted the contained government.
What
order
was the-
limiting the eligibility of the basic only to such those candidates who have passed B.Ed from the institution recognized by so and so arbitrarily. The High Court held that the exclusion of candidate from the field of eligibility for the said course who have obtained B.Ed degree prior to the enforcement of the so and so or after the enforcement of the act during the period when the application of any institution or university was pending consideration arbitrary and reasonable
Yes, my lord.
violation of Article 14 and 60 of the Calling Law.
My lord, your lordship remembers proviso, first proviso to section 14(1) provides that the existing institutions which are offering a course or training in teacher education before the appointed date, they can make an application within 6 months in order to continue. That was extended. That 6 months period was extended, my lord.
Only for the existing institution.
Only for the existing institution, as I have shown at page 73. Now, during the pendency of their application, those who have passed BA, they were not recognized. So that was the issue in Bhupender Nath Tripathi's case. But Bhupender Nath Tripathi, my lord, discussed the first proviso to section 14(1), and that my lords will find at page 213. 213.
Yes.
Paragraph 25 deals with 16, my lord. Section 16 of the Act mandates that the affiliating body grant affiliation only after institution concerned has obtained recognition from the regional committee concerned under Section 40 or permission for the course of training under Section 15. Section 17(3) declares that once recognition of a recognized institution is withdrawn under subsection 1, such institution discontinue the course or training in teacher education and university concerned, or the examining body shall cancel affiliation. We're not concerned with that. 27, if my lord will kindly come to. The proviso to section 14(1) states that an institution offering a course or training in education immediately before the appointed date shall be entitled to continue such course or training for a period of 6 months if it had made an application for recognition within the said period and until disposal of their application by the regional committee. Now, the rest I'm not concerned. Then next page, my lord, will see paragraph 28. A plain reading of the provisions suggests that all such institutions offering a course or training in teacher education prior to the act coming into force are entitled to continue. So my submission will be they are not institutions which was offering a course prior to coming into force of the immediately before the NCTE came into force. Even my lord, just 2 lines at page paragraph 30, my lord, just below that. What was the stand of the NCT? NCT made its stand clear, as it is evident from the impugn order that after enforcement of NCTE, the existing institution on the appointed date offering a course of training in teacher education are entitled to continue. So repeatedly it has been held. Now, my lord, my learned friend, my lord, has cited a decision of Allahabad High Court. Ekta Shukla. This is it's my lord, I have it AIR 2000, no, what is that Ekta Shukla? Yes. My lord, Ekta Shukla, if your lordship will see, I have also given. In his compilation also it may be there. Paragraph 4, your lordship will see the facts, that's all, 2 lines. Paragraph 4.
Paragraph 4 of the judgment.
Of Ekta, yes, my lord. Allahabad judgment. my lord.
Allahabad Judge Sampurna Sanskrit University.
That, yes, my lord. Sampurn, that was,
SP judgment.
yes, that there was an appeal, my lord. And I'm reading this from division bench judgment, which I have.
Division bench.
Yes. No, your lordship aware doctrine of merger will come, single bench judgment cannot even be referred to unless for a specific purpose. I've given a copy to your lordship. This is paragraph 4, my lord will see.
Yes.
Paragraph 4. The matter relates to. Which page? Page 20 perhaps of their compilation, my lord.
Page
20. It is not numbered, but fourth, it's mentioned in the division. bench.
Eknath Shukla, okay, ठीक है. Page
Fourth.
20, yeah.
Paragraph 4, देखिए.
Yeah.
Matter relates to recognition of certain colleges affiliated to Sampurnanand Sanskrit Vishwavidyalaya Varanasi. So these institutions were already recognized by Sampurnanand Vishwavidyalaya. They came into force after the NCT came into force.
This existence of the institution is 30th of December 1995, whereas the last date was 1/7/1995.
1/7/1995. So this judgment is of
How
no.
to overcome this observations and the findings of the division bench in the earlier judgment?
Yeah, I'll come.
Though you have specifically said that that was in relation to the powers of the NCT to extend the date or not.
Yes, yes.
But despite that, specific finding regarding this degree of respondent number 7 and another person that they are recognized for all.
Seven was a party. Seven was not a party. The present respondent was not a party.
Then respondent was party in that.
No,
Six
no,
and
no,
seven का नहीं था.
no, नहीं था party.
Govind and.
Govinda Chakraborty is same school, same university, same college.
Okay.
He's not the party.
No, no.
My lord, I can tell your lordship. If something is mentioned in the division bench judgment, it will not even be omitted. In all respect, my lord. Because Chagla's judgment is very famous judgment on it. Madan Lal, Ishwar Lal, where Justice Chagla, my lord, when he was Chief Justice, Bombay High Court. In the same judgment, I have given in my compilation, your lordship will see, he has, especially by Justice Bhagavati, that then my lord, who wrote the judgment. He said with all due respect, the judges of the Supreme Court has not applied their mind. It was interpretation of section 167, 8 of the Sea Custom Act, my lord. And there Justice Bhagavati said the maximum that penalty can be given. My lord, it is. I'm not going to refer, but your lordship will just see. I'll just give the reference, my lord. Mohandas Ishwar Das, it is AIR 1955 Bombay 113. And in this compilation, it is at page 92. I'll not refer to it. But I'm just saying, because my lord, the division bench is very emphatic in saying what is the issue in the case.
It's a beautiful way to insist while saying that I'm not referring to it.
My lord, all right. If your lordship, my lord, if your lordship so desires, your lordship will come to page 95. I'll read it. There is 95, if your lordship, of this compilation.
Yeah.
I'll place it. I'm just placing, my lord, the relevant portion. Therefore, on the face of it, again, and with very respect, the observation of Justice Bhagavati does not seem to be correct. Justice Bhagavati gave the judgment in the Supreme Court. It is therefore obvious that the learned judges of the Supreme Court did not apply their mind to the construction of various items of 167, nor decided what were the powers of custom authority under various items. The observation is made in passing with the reference of general scheme of the Act. And in our opinion, it is entirely untenable to suggest that this general observation constitute an obiter dictum, which is binding on this court on the question of interpretation of section 167, item 8. Question which never arose before the Supreme Court, which was never considered by the Supreme Court, which was never decided by the Supreme Court. That will not constitute obiter, my lord. In our opinion, therefore, the learned judge was in error when he took the view that this observation in the judgment of Justice Bhagavati overruled the judgment delivered by State versus Nur Muhammad. That judgment was delivered by Chagla. And what surprised me, my lord, in 1961, Supreme Court followed this without making a reference. Now I'll take your lordship to 185, page 185. Page 185, my lord, of the division bench judgment.
Page
185 of division bench judgment. What was the issue? 185. I've taken your lordships already. 185.
Yes, you have already mentioned.
Yes, I've
The
already.
issue was regarding the power of the NCET, whether they have power to extend the date or not.
Well,
That's the only issue, yes.
Absolutely, absolutely. Now, my lord, therefore, the Ekta Shukla goes. It is for the existing institution. My learned friend has cited another decision, which is 2001 Rajasthan High Court.
Where in the section 17 for validity of that.
Yes, my lord, that was overruled by the Supreme Court. In, copy. My lord, this was overruled in 2002 8 SCC 228 Union of India and others versus Shah Govardhan Kavra.
Only we have asked, once Mr. Goswami, what is the status? Still holds the field or not?
My lord, may kindly come to 735. My lord got it. Paragraph 10, page 235.
Yes.
In the aforesaid premises, the conclusion of the High Court that section 17(4) is ultra vires beyond the competence of the Union Legislature cannot be sustained, and the said conclusion is accordingly set aside. On examination, the statute as a whole, on scrutiny of the object and scope of the statute, we have no manner of doubt that subsection 4 of section 17 is very much a law dealing with coordination and determination of standard of institutions for higher education coming within entry 66 list 1 of the 7th schedule, and thus Union Legislature did have competence for enacting the said. It was- So, my lord, this is my submission. Another one is, my lord, 2023 10 SCC. That was ED Director, my lord, Sanjay Kumar Mishra. That's not relevant in my humble submission. Therefore, my submission would be that unless he makes out a case that he comes within the first proviso of section 14(1), he doesn't have a case. I'm grateful, my lord.
Ekta Chopra also filed appeal SLP to Supreme Court, that was dismissed.
Facts.
Argument, sir, judgment as well.
Well,